right, good morning, everybody. Welcome to the Committee on Veterans and Legal Affairs. We're assembled virtually today to hold a public hearing on LD 1642 and then work a number of bills that are before this committee. But before we get started, we'll have committee members introduce themselves, and we'll begin with Chairman Chiazzo.
Thank you, Mr. Chair. Good morning, everyone. Happy Friday. My name is Chris Chiazzo. I am the representative for House District 28, which is part of beautiful, sunny West Scarborough.
Great. Senator Farron.
Good morning, Mr. Chair. My name is Brad Farron. I live in Norridge Walk and represent Senate District 3, which is the majority of Somerset County.
Great. Representative Kinney.
Good morning. I represent House District 99, which are 9 towns in western Waldo County. I'm going to sneak down to my sugar house. I'm only going to be on my own property at the moment. Driving down the road, and then I'll stay put for the rest of the day.
Representative Supika.
Good morning. My name is Laura Supika, and I represent House District 126, which is a portion of Bangor.
Representative Riley.
I'm Representative Riley. I represent House District 34, which is part of Westbrook.
Representative McCrate.
Good morning. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Representative Wood.
Good morning. I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Corey.
Good morning. I'm Patrick Corey. I represent House District 25, which is part of Wyndham. Thank you.
Great. And my name's Louis Lucchini. I represent most of Hancock County in the Senate. With us today, we have our committee analyst, Janet Stocco, and we have our committee clerk, Karen Montel. So just to cover a couple things about electronic committee hearings, reminder, this is being live streamed on the committee's YouTube channel. So anybody can be seen and heard if your microphone is unmuted. People waiting to testify, will bring you in to the meeting. It may look like you're being dropped for a second, but be patient. You'll pop onto our screen, and then once here, you'll be able to turn on your mic and turn on your camera and submit your testimony. The audio is being live streamed as usual on the legislature's website, and on our website, you'll also be able to find written testimony from anybody who chose to submit it through the portal. Again, reminder that the chat function of this is for technical assistance only. For our bills today, we just have one, LD 1642. We'll begin with the sponsor, and then we'll allow for public testimony. Please tailor your remarks to 3 minutes. And for members of the public, please remember to state your name, the organization you represent, if any, and your residence. So with that, I'll turn it over to Chairman Chiazzo.
Thank you, Mr. Chair. And we will open the public hearing on LD 1642, an act to allow affirmation of local option referendum by municipal officers or county commissioners. And to introduce us and present that bill, I will introduce Senator Lucchini.
Thank you, Chairman Chiazzo. So good morning, everybody. Again, I'm Louis Lucchini, represent most of Hancock County in the state Senate. I'm here to present LD 1642, an act to allow affirmation of a local option referendum by the municipal officers or county commissioners. So this was kind of an issue that arose last session. In our statutes, which go way back to immediately post-prohibition, there's a requirement in law that in order for a town to be able to sell alcohol, you must first hold a local option vote to opt in to be able to sell alcohol. Most votes were taken decades ago. And, you know, since the votes were first taken, the questions have changed over the years. Some towns may have lost their records. Some town halls have burnt down, things like that. So last session, we ran into a specific situation, excuse me, where someone was applying to get a liquor license, I think in the town of Turner. And we were working with Senator Timberlake, and Bablo realized as they were going through the licensing process that the town hadn't taken their local option vote on this. And then, we worked with Bablo and Tim Poulin, Greg Minio, and they were great in looking through the records. And it turns out we went through and they found dozens of municipalities whose records were incomplete, which technically, would mean that those towns wouldn't be able to sell alcohol like at a restaurant, convenience store, things like that. And so a lot of these towns, that activity is already happening. So we didn't want to stop and close down any of these towns. And it was, dozens and dozens of towns. So last session, we set up kind of a grace period to allow for towns to take their local option votes and get their records in order. I think it was a 2 or 3 year grace period. Obviously, the pandemic hit, and then nobody was holding local referendum votes. So this problem persists. And as towns now are budgeting for their local option votes, this proposal came forward. And honestly, I'll just recognize Angela Holmes, who's here to testify, as well as Bablo and Maine Municipal Association. They really worked out proposed language on how to fix this problem, which which I'm supportive of, and it looks good to me. Just essentially allowing an affirmation of a previous vote, saying that if you took a vote prior to 1977 that approved one or more of those questions at the time, that it can be, I guess, interpreted to apply to all questions. But really, they all did the work. They were just looking for a sponsor and asked me to put this in for them. And, they've done great work to come up with some language that should hopefully resolve the problem if the committee agrees with it. So with that, I will conclude and happy to take any questions.
Thank you, Chairman Lucchini. Any questions from the committee? All right, seeing none, then we will move to the public portion of the hearing. I will introduce Angela Holmes. We'll bring her in first. Let her speak. She'll be followed by Director Minio and then Greg Dougal. Ms. Holmes, you can start when you're ready.
Hi there. Can everyone hear me?
We can, yes. Thank you.
Good. Thank you so much. Senator Lucchini, Representative Chiazzo, and members of the Joint Standing Committee on Veteran and Legal Affairs. I am Angela Holmes, Assistant City Administrator and City Clerk for the City of Westbrook. And today I'm here providing testimony in favor of LD 1642. The City of Westbrook drafted this bill in consultation with the Bureau of Alcoholic Beverages and Lottery Operations, BABLO. Maine's liquor law requires municipalities to hold a local option vote, or referendum, to authorize the sale of liquor in their community. Over 300 municipalities throughout the state of Maine sent these referendum questions to voters prior to 1977, at which time state liquor law named specific establishment types within the referendum questions, such as hotels, clubs, and restaurants. In 1977, the state amended the referendum questions to remove reference to specific establishment types. However, the consequence of this action meant that municipalities that voted prior to 1977 had effectively limited the issuance of liquor licenses to only those establishments called out in the original referendum questions. So Public Law 2019, Chapter 672 was enacted last year, which gave municipalities until July 1st of next year to provide evidence of the results of any local option election. Due to the 1977 language change, the majority of Maine municipalities are now required to resubmit the local option vote questions to referendum if they wish to allow their businesses to continue holding liquor licenses. LD 1642 was drafted as a response to this historical anomaly and intends to simplify the procedures to bring municipalities into compliance with liquor licensing requirements. For those municipalities that held a local option vote prior to 1977, provided that the voters approved the referendum questions, LD 1642, as originally submitted to the committee, would allow the municipal officers to affirm that this prior authorization is considered approval for all types of establishments that may be licensed by BABLO. This was proposed as an alternative to the referendum requirement that the majority of Maine municipalities would otherwise be required to conduct. However, after recent discussions with the Maine Municipal Association in Bablow, just in the last 48 hours, we have developed a proposed amendment to LD 1642, which more cleanly addresses the issue at hand. And the proposed text of this amendment has been sent to Senator Lucchini and to the VLA committee staff to pass along to all members here today. This amendment simply extends the approval previously granted by a municipality through referendum vote to all types of establishments that may be licensed by the Bureau to sell liquor for on-premise consumption. The original language in the bill would require additional municipal action. This proposed amendment, coordinated with MMA and Bablow, simply continues any previously granted approval without the need for additional municipal action. We believe that this proposed amendment addresses what really ought to have been adopted prior to 1977 to protect the intent of voters based upon those original local option votes. Again, for over 300 Maine municipalities that acted in good faith over 40 years ago to allow liquor licenses, that referendum approval will be extended without the need for an additional referendum. So as I noted, that the text of that amendment has been passed along, though I'm happy to read through it if the committee desires. It's relatively short.
If you'd like to, Ms. Holmes, that's up to you. We have the language, so I think we're okay. But if you want to walk us through it, you're welcome to.
Since you all have it in front of you, I'll skip on that, but I just want to provide a little bit of background on that amendment as well. This amendment does not change the intent of the bill, which is to eliminate the requirement of an additional referendum to approve something that was already approved by voters over 40 years ago. Conducting a local option referendum constitutes a significant burden for municipalities that have already taken action to authorize liquor license sales. Due to municipal budget adoption schedules, municipalities need to decide soon when to send this question to referendum if a decision must be made before July 1st of 2022, and to avoid putting currently licensed establishments at risk. I want to thank Senator Lucchini for sponsoring this item, for MMA and for Bablow for coordinating the language of this proposed amendment, and to the Legislative Council for approving this item as an after deadline emergency bill. Thank you for the opportunity to share this testimony this morning, and I'm very happy to address any questions that the committee might have for me.
Thank you, Ms. Holmes. Representative Riley.
Thank you, Mr. Chair. Hi, Angela. It's nice seeing you, and welcome to VLA. And again, thank you for all the work you've put into this bill, Senator Lucchini's bill. So thank you so much.
Representative McCray.
Thank you, Mr. Chair. And Ms. Holmes, thank you. I just want to ask you if an area has never did take a referendum on this, they would still do that. Is that right? And I assume there are some who haven't.
That is correct. So if a municipality has not yet voted on any local option question, they would still need to send that to referendum. Or if a municipality perhaps sent it to referendum, but the voters voted no on any of the questions, if they wanted to reconsider that decision, that would again have to go to voters at referendum. But for the vast majority of municipalities, they took whatever the standard language was pre-1977, sent that to voters, and it was approved. And so again, this would be an easy option for most municipalities, but you're absolutely correct that there are some municipalities that would still need to send this to referendum if any voters voted no, or if perhaps they're a dry town and they want to reconsider that.
Right. Thank you. And just to follow up, Mr. Chair.
Sure.
So this would make this going forward. This isn't a time limited issue, right? We would have this in statute. It wouldn't sunset.
Correct. That is my understanding, though. I'll definitely allow MMA when they testify to provide additional information on that.
Great. Thanks very much.
Yeah, I don't see a sunset in the amendment, but I'll look at the main bill. We can also, we can take a peek as well. Any other questions for Ms. Holmes while we have her here? All right, seeing none. Thank you, Ms. Holmes, for the amendment and the work you guys are doing. We appreciate that.
Thank you.
Up next, we have Director Minio. Good morning, sir. The floor is yours when you are ready.
Good morning. Good morning. I had to get all my electronics going there. Senator Lucchini, Representative Cayazzo, members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Greg Minio, and I'm the Director of the Bureau of Alcoholic Beverages and Lottery Operations, and I am providing the following written testimony in support of LD 1642. The Bureau has been working on issues surrounding local option votes for about 3 years now, actually. In the legislature, LD 2120 passed as Public Law 2019, Chapter 672, that amended the ways municipalities could get local option votes to the voters. The law also directed the Bureau to send a notice to every municipality and county commissioner on the Bureau's records regarding local option votes taken by those municipalities and the county commissioners. The Bureau complied and sent those notices providing great detail on the voting records specific to the municipality or county. Regardless of the thoroughness of the notices, there were many questions and even some confusion. Deputy Director Poulin fielded approximately 100 questions by telephone and email. Overwhelmingly, municipal officers were concerned about the need to send questions to voters that had been approved and the impact of a potential change from a yes vote to a no vote, what it would have as far as on existing licensed establishments. The bill before you today resolves those concerns as it provides another option for the municipalities to exercise to resolve any issues created from the change in the local option vote questions language in 1977. Until 1976, there were 17 local option vote questions in the former Section 101 of Title 28. There were 10 of those 10 questions that dealt with consumption on the premises on days other than Sunday. Those questions specified the types of establishment and the type of alcohol that could be served at those establishments. For example, a Class A restaurant was not permitted to serve malt liquor, and clubs and taverns were only permitted to serve malt liquor. Fast forward 50 years today, there are 31 types of establishments that can be licensed for on-premise consumption, 17 that should not be permitted to be licensed in over 270 plus municipalities because these types of liquor licenses didn't exist then, but have been approved by the municipalities and licensed by the Bureau over the years. For further illustration on this issue, the Bureau's issued licenses to 378 businesses, Class A restaurant lounges. It's more likely than not that at least 90% of the municipalities, including Portland, Lewiston, and Bangor, are largest population centers for the license types that have the restricted to votes reference from the 60s and the 70s that did not include this type of establishment. Upon further review of the language in the bill with our Assistant Attorney General, the words, and I quote, "for on-premise consumption," end of quote, should be added for clarity to the end of the sentences on lines 16 and 19 on page 2 of the bill after the words "by the Bureau." We encourage the committee to vote ought to pass on this bill to give municipalities another option to resolve these matters. And I would concur, and I thank, I'm sorry, is it Angela? I apologize. Angela, thank you for coming to the table with us and working so hard with Tim Poulin on this. And this has been a lot of work, and we thank you for that. So I'll take questions and I'll be available for the work session. Thank you.
Thank you, Director Minio. Any questions for the director? Bear with me just for a second here. Okay, Director Minio, I'm not sure if this is a question for you or not. Do you know if the intent of the amendment is for the local option vote for all days other than Sunday for future licenses, or will also be limited to days other than Sunday? Or is it any positive local option vote prior to 77?
I believe it's the latter. I've got Deputy Director Poulin, if it pleases the committee. May we ask him to answer that question so you get it? He's been very close to the action on this. Is that okay, Representative Cayazzo?
we'll bring him in to testify. I don't know if we could really do the back and forth.
Okay.
I'll bring him in after we get through the public.
And we can
hearing.
go to the work session if you want to do it
Yeah.
that way. And my understanding, it is to the latter. It's to all of it.
Okay.
Yes.
Okay. All right. Thank you, Director. Any other questions for the Director? All right. Seeing none. Thank you, sir. We will look forward to seeing you at the work session for sure.
Thank you.
Up next, we have Greg Dougal. Actually, you know what? Let's bring in Mr. Poulin now. And then after Mr. Poulin, we'll have Greg Dougal and followed by Lisa Goodwin. So Mr. Poulin, there you are, sir.
Good morning.
Good morning. So it's a little unusual. Typically, we don't do this in a work session. I mean, in a public hearing. But I think in the interest of time, I will ask you that question, sir. If you could introduce yourself and let everybody know who you are.
Yes, I'm Tim Poulin, the Deputy Director at the Bureau of Alcoholic Beverages and Lottery Operations. I live in Sydney, Maine.
All right, thank you, sir. Did you hear the question prior, and do you understand?
Yes, and so as Director Minio testified in his testimony, prior to 1977, of the 17 local option vote questions, there were 10 that were related to on-premise consumption. 5, and these are the words in the statute, on days other than Sunday, and then 5 for Sunday. So the amendment that Angela has presented to you would provide a continuation of those affirmative votes on both days other than Sunday and Sunday.
All right, thank you, Mr. Poulin. Are there any questions for Mr. Poulin while we have him here? All right, seeing none. Thank you, Mr. Poulin, for your impromptu testimony. It is much appreciated.
My pleasure.
Up next, we will recognize Greg Dougal, and he will be followed by Lisa Goodwin. So thank you, Mr. Dougal, for joining us, and you may start when you are ready, sir.
Thank you, sir. Senator Lucchini, Representative Caiazzo, and members of the Joint Standing Committee on Veterans Affairs. My name is, of course, Greg Dougal, and I am submitting testimony today representing Hospitality, Maine in support of LD 1642 and the amended version, which I just heard as well. This would obviously solve an ongoing issue about how to get cities, towns, and unorganized territories in compliance with Title 28A requirements for local options approval for licensing on-premise and of course off-premise as well, but I do on-premise license categories that did not exist when the original local options vote was taken back in the 70s. We have several members in several communities that fall into these categories, and current statute would require another referendum on these local options for approval or closure of these facilities. And Senator Lucchini was good enough to keep me in the loop on this whole issue starting, as he said, 3 years ago. And it has been a sizable issue for our membership. I also want to thank, as has been done, Angela and Tim Poulin for being part of the process that actually created this new amended version of it. And it looks as though the clerks in the communities, the city and town clerks, from the list of people who were either given written testimony or verbal testimony, seem to be very much in favor of this. It would be very helpful to us, especially after what we've been through the last couple of years. So thank you very much, and I'm happy to answer any questions if you have any.
Thank you, Mr. Dougal. Any questions from the committee? All right, seeing none. Thank you, sir, for your testimony this morning.
Have a good day. Thank you.
Thank you, sir. You as well. Up next, we have Lisa Goodwin.
Good morning, Senator Lucchini, Representative Caiazzo, members of the Veterans and Legal Affairs Committee. I am Lisa Goodwin. I'm a member of the Legislative Policy Committee for the Maine Town and City Clerks Association and the City Clerk for the City of Bangor. Patty Du Bois couldn't be here today, so I am filling in for her. The Maine Town and City Clerks Association is in support of LD 1642, and we thank you for the opportunity to outline our points. Legislation adopted last year will require potentially hundreds of our municipalities to send the local liquor option votes to referendum again. As an alternative to this requirement, this bill would allow municipal officers to affirm the scope of any prior local option votes. Those municipalities with town meeting style government may still have to conduct referendums along with municipalities that have no record of a previous local option vote, but for other municipalities, this provides an alternative option. Maine clerks are in support of this bill as it will offer some flexibility to our diverse cities and towns, which will likely result in significant cost savings if referendum elections are not held. The Maine Town and City Clerks Association appreciates this opportunity to share our testimony, and I'm happy to answer any questions you may have. Thank you.
Thank you, Ms. Goodwin. Any questions from the committee for Ms. Goodwin? All right. Seeing none, thank you for joining us this morning.
Thank you.
Up next, it looks like we have Melissa Packard. Let me bring Melissa in. There's Melissa. All right, Ms. Packard, thank you for joining us. The floor is yours when you are ready.
Thank you. Senator Lucchini, Representative Cayezzo, and members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Melissa Packard, and I am the Director of Elections and APA in the Office of the Secretary of State. I'm speaking today neither for nor against LD 1642. The Division of Elections within the Department of the Secretary of State has a ministerial role in the local option referendum procedure. Pursuant to Title 28A, Section 121.3, the certified results of any local option vote must be sent to the Secretary of State. The Secretary of State, in turn, forwards the results to the Bureau of Alcoholic Beverage and Lottery Operations, BABLO, so that licenses can be issued to businesses in that municipality. We interpret this bill to provide that municipal officers or county commissioners can vote to affirm the results of a prior local option election. The municipal office or county commissioners must then file the affirmations with the Secretary of State so that we can place them on file and forward to BABLO. Although the number of filings may increase temporarily as municipalities act to meet the requirements of law, the Secretary of State can continue to file and forward all results received in a timely manner. The final decision of whether sufficient proof of the results has been provided will remain the purview of BABLO. I thank you for the opportunity to speak today, and I'd be happy to answer any questions.
Thank you, Director Packard. Any questions from the committee? All right, seeing none, thank you, Director, for your testimony this morning. We appreciate that. All right, that concludes the list of registrants in favor and neither for nor against, pre-registered. If there's anybody in the attendee room who wishes to speak to LD 1642, if you could raise your virtual hand, we will bring you in and allow you to speak. All right, seeing none, we will close the public hearing on LD 1642, and I will turn the gavel back over to Chairman Lucchini.
Great. Thank you, Mr. Chair. So that concludes the public hearings for the day. We're scheduled for 10 a.m. work sessions. So we'll take a recess for about half an hour to do some, I guess, caucusing and get ready for the work sessions. So Janet, am I missing anything else we're supposed to do this morning, or?
Not that I know.
Okay, thanks. All right, so with that, we'll recess and come back at roughly 10 o'clock. So, and same link will bring you back.
Hi, boy. Hi, boy. Hi, boy. Did you tinkles? Did you go tinkle? Did you tinkle? Hey, boy. Did you tinkle? Did you tinkle? We're gonna have to figure out a different sleeping arrangement for you if you
Okay, we'll get started in just a couple minutes. We have a lot of members who are serving on multiple committees today and testifying in multiple committees today. So we're just trying to get enough people back so we can have enough to vote. But yeah, people are serving in multiple committees. It's the busy time of year for us in the legislature. So we'll see if we can get some people in. Okay, we'll shoot for getting started in just a couple of minutes. Again, apologies to people waiting. It is every legislator is in multiple committees at once right now, so makes it a little tough to get a quorum to vote. So we'll start in 2 minutes. Okay, so we're going to get ready to head back and get started just so we can move through some of these bills. We've got a number of bills before us this afternoon. And also just a notice to everybody, I'll say it later, but we just got a notification from the presiding officers that looks like if you're absent for a vote, effective immediately, a member who is absent from committee at the time of the vote must register the vote by noon on the next business day following the vote. So just something to keep in mind, and we'll say it again later for people who aren't able to be here now. Okay. Okay, so we're still with 5 members. We need 7 to do any voting. So we can perhaps try to track down a couple more people. Like I said, I know a lot of people are in different committees at the moment. So I guess just to cover one thing briefly. So we have LD 1643 on our agenda, which is we had planned for a carryover discussion without going through the process of public hearing and everything else, because this one is the bill that this committee spent the last 2 years. It was a subcommittee, and Janet basically just went through the entire title to try to fix any errors and conflicts. That way it makes it better for more consistent for those in the industry and better for the Bureau in terms of enforcement. But this one just came out. It's over 100 pages and it's largely just technical things. So we were thinking that this would be a perfect model for a carryover, since we just don't have time to go through this, but it was something that the industry thought would help, I think, from all ends of the industry, just to have clearer laws. And the title hadn't been recodified, I think, since like 1987. So it was just trying to clean up a bunch of things. So if people are good or have any thoughts, we can do that. And this may be something we'd want to do a subcommittee over the summer or something to work on the language, but it's a bit of a monster of a bill. And we've also passed a bunch of laws that directly conflict with this that are going to have to be reviewed. I feel really bad for Janet having to look through all of that stuff again. But yeah, I don't know if anybody has thoughts on that, or if we can, if people are good, we can also vote to carry it over or kill it, whatever the committee wants. Chairman Chiazzo.
Thank you, Mr. Chair. No, I think this is a great, obviously the work needs to be done. I just don't think we're running out of time to do it with a 100-page bill. So I would certainly be in favor of a carryover if that were the case, and we can always work on it over the summer with a select group if we need to.
Great. Representative McCray.
If you're ready for a motion, I would make a motion to carry over LD 1643.
So we have a motion to carry over LD 1643 by Representative McCray. Is there a second?
Yeah.
Second by Representative Supika. Okay, any discussion on the carryover motion? Okay, we have 7 members present, so we're able to vote. So Karen, if you would please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley. Representative Riley, absent. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dawes. Representative Dawes, absent. 7 in favor of the motion, 0 opposed to the motion, and 6 members absent, Mr. Chair.
Great, thank you, Karen. I believe carrying over is a vote of those present, so I think that kind of we'll be adding that to the list of carryovers, which if we have anything else that the committee wants to do, we can add to that as well. So, okay, that we'll close the work session on LD 1643. I think next up we have we'll go to like a joint analysis. It looks like LD 1093 and 1358. Janet.
I'm just calling it up on my screen. Okay, I was very delighted during the public hearing to have a specific request to compare these bills side by side. That made me extremely delighted. So thank you, Representative Kinney. Currently, an in-state or out-of-state winery or small winery may obtain a license to ship its wine directly to Maine customers. LD 1093 would expand the type of entities eligible to receive licenses for direct shipment of wine to Maine customers, and the expansion would include off-premises retailers and wholesalers that are licensed in this state or another state. LD 1358 takes a different approach, and it would authorize in-state or out-of-state distilleries to obtain a license to ship their products directly to Maine customers, so spirits products instead of wine. And at the public hearing, the sponsor proposed amending the bill to authorize breweries to ship malt liquor products directly to Maine customers as well. Neither of the bills would eliminate the current authority of wine manufacturers to have a direct ship permit. These bills would just expand to new additional licensees as well. So if we first look in this first row across, these are the licensed entities that are eligible for the direct shipper license. So as you can see, currently it's in-state and out-of-state licensed wineries. Senator Miramont's bill would add to that wine retailers, they're off-premises retailers, as well as wine wholesalers, as long as they're licensed in this state or another state. Senator Stewart's bill, as amended, would add distilleries and breweries. There is one interesting thing I noted in his amendment. Instead of saying an out-of-state brewery that's licensed in the other state, his proposed amendment would say an out-of-state brewery that has a certificate of approval. For the newer members of the committee, a certificate of approval is issued by the state of Maine that allows you to, from our perspective, import your products into Maine. From your out-of-state perspective, export your products to Maine. So that's a slightly different approach. And I get into that a little bit in the notes below. So Senator Stewart's bill would not add retailers or wholesalers, however. So he's just going to add manufacturers of spirits and malt liquor, while Senator Miramont just keeps in the wine field and he adds retailers and wholesalers. Another thing to look at are the types of products. So current law, it's only wineries and they have to ship only their own wine, and they're not allowed to ship wine coolers. Senator Miramont's bill, which expands that to retailers and wholesalers, because those entities don't produce wine, they're not limited to their own produced wine. It's now any wine can be shipped by any of those entities, and it doesn't have an exclusion for wine coolers anymore. And Senator Stewart's bill and amendment, they involve, again, only manufacturers, so the spirits that are produced by the shipper or malt liquor. And the way that the amendment is written, it's malt liquor either produced by or on behalf of the shipper. So it's my understanding that sometimes breweries sort of subcontract the brewing of their special recipes. Somebody who's involved in the field can explain that better than me. And this would allow them to use those subcontracted brewed bottles of malt liquor to be shipped as well directly. Container size, there are some differences. So current law for shipping of wine directly to customers, the container has to be above 3/4 of a liter. Senator Miramont's bill would eliminate that restriction. For Senator Stewart, when he's talking about spirits, he would keep that restriction. You need 3/4 of a liter above, but he wouldn't have a restriction on the bottle size itself for malt liquor. Then as far as the maximum amount that can be shipped to a customer, under current law for wine, it's 12 cases, and a case would be up to 9 liters total of wine, and that's per recipient address per year. Senator Miramont's bill, which again is still wine, but it expands to retailers and wholesalers, would allow doubling of the amount per recipient to 24 cases. And again, it's per address per year. Senator Stewart's bill as drafted, which just talks about spirits, is less. It's only 4 cases. And again, the same case size for spirits. And as far as his proposed amendment for malt liquor, it would be 12 cases, which is the same as current law, but it changes it to the way that cases of malt liquor are discussed. So it's the equivalent of 24 12-ounce units. Now remember, it doesn't matter here what the bottle size is itself. It's just so the equivalent of 24 12-ounce units. The only difference in his amendment is that it says to any one person per year, as opposed to current law. And the other, the bills as drafted are talking about the recipient address per year. So I didn't know if that was intentionally different. I'm sure we can figure that out, though. We can work that out. All of the current law and all the proposals before you have the same fee scheme. So it's a $200 initial license fee, $100 initial registration fee, and then $50 annual renewal. None of that's changed. All of the bills before you in current law don't allow you to ship to an area that's voted against all local option questions. So no dry municipalities can have shipments sent there. All of the bills in current law all have the same protection for minors. So the package has to be labeled in all caps that it contains alcohol, and someone has to sign who's 21 years of age or older. All of the proposals in current law require you to use a common carrier to make the shipment, and the carrier must obtain the signature of someone 21 years of age or older, and they have to verify that with a photo ID. And that person has to be at the address listed on the shipping label. So current law, as far as sales tax, says that if you're an out-of-state shipper, as a condition of getting this license, you have to agree to comply with our state sales tax rule, laws and rules regarding sales tax registration, collection, reporting and remittance. That's preserved in both bills before you. As far as the proposal from Senator Stewart to add malt liquor, if you remember, I said instead of saying an out-of-state, any out-of-state brewery could send its malt liquor, it only allows in his amendment any out-of-state brewery that has a certificate of approval to import its products into Maine. And so it's slightly different, and it says as a condition of that certificate of approval, it's supposed to comply with all sales tax requirements, but it still has the same effect that anyone from out of state who's authorized to ship under any of these pieces of legislation would have to register, collect, report, and remit sales tax. As far as excise tax provisions under current law, wine has an excise tax in section 1652 of Title 28A, and direct shippers have to comply with that and pay all excise tax due for all of the products they ship to Maine customers, and they do that by filing annual reports and making those payments. Senator Miramont would not change that for his wine bill that involves retailers and wholesalers, so they'd have to follow that same process. For Senator Stewart's bill, it involves spirits, so spirits aren't governed by that same excise tax provision of Maine law. The way spirits work is, if you recall from a long time ago when we did the presentation on spirits pricing, when the State Liquor and Lottery Commission sets the retail price of spirits, it includes a markup that has what's components that are including the state spirits tax. And that is all rolled into the retail price. Instead, for these out-of-state shippers that are going to be shipping into Maine, and as well in-state shippers that are going to be shipping directly to Maine customers. Instead of going with the State Liquor and Lottery Commission's marked up retail price, they would be directed to pay an excise tax of $11.96 per gallon. And then for malt liquor, which he adds in his proposed amendment, he follows the same model as wine, because wine and malt liquor are treated the same. They have their own specific excise taxes. As far as the beverage container law, current law for direct shippers of wine, which are just wineries, if you remember, they do not have to follow the beverage container law. Senator Miramont's bill, which expands it to include wholesalers and retailers, does require all direct shippers, so that would include the ones that do it now. All of them would now be required to follow the beverage container law for their wine shipments. For Senator Stewart's proposal for spirits and malt liquor, which are just limited to manufacturers, he would not apply the beverage container law. There are reporting requirements in current law for all direct shippers. They have to annually report to the Bureau the total cases they ship to Maine, the names and addresses of all the recipients, and the date, quantity, purchase price, and common carrier used for each of those shipments. Senator Miramont's bill would keep that, as well with Senator Stewart's bill as drafted for spirits. It's not required in his proposed amendment for breweries. I don't know if that was intentional or not, but I did want to point out to you that that provision was not included in his proposed amendment. Current law also has a separate line in the reporting provision that says if you're an in-state direct shipper, you also have to annually report the total cases you shipped to out-of-state recipients, which is a little bit weird because your license under this section is only to ship to Maine recipients. But if you remember, there was a bill earlier this session where you clarified the authority of manufacturers if they're allowed to in another state to direct ship to customers in those other states. So this provision would say if you also have an in-state direct shipment license, you're going to have to be reporting all of your out-of-state direct shipment sales to the Bureau on an annual basis. Senator Miramont's bill keeps that for the wholesalers and retailers that might be able to ship wine as well. Senator Stewart's bill does not require that for any of the distilleries or breweries that are in state that are going to be shipping out of state and also happen to get the direct shipper Maine license as well. He doesn't include that reporting requirement. I would point out that in the bill you passed, it's pretty clear that excise taxes and state spirits tax don't apply to shipments from a Maine manufacturer out of the state. So I don't know how that affects whether you think this report is required, and they may in fact already be reporting it anyway. So that's sort of a side comment. All of the bills and current law require or state that the Bureau can perform compliance audits and the shippers have to cooperate by turning over records within 10 days, etc. There's also in current law a violation specified if you don't have a license and you directly ship. The first time it's a $500 fine. After that, it's up to a $1,000 fine. None of that's changed. If you knowingly deliver to a person who's less than 21 years old, this mostly applies to the common carrier, then you can be fined up to $5,000. That does not change in any of these proposals. And then if you ship more than you're allowed to under the particular statute, either the size of the bottle itself is too small for wine or spirits, or the maximum amount has been exceeded for any one recipient address, then the Bureau has authority to suspend or revoke the license. They can also accept what's considered an offer in compromise. That's how it's written in the statute, which basically means they work out an agreed fine that the court has to approve. There were many questions during the public hearing about the beverage container law and how it works. I am not an expert on this law. I did reach out to Dan Tartikoff, our OPA analyst who does work in this area, and he provided some resources. And I did provide a link here to the Department of Environmental Protection's overview of the bottle bill. It's pretty short, and you can look at that through that link. And then also, I don't know if you remember, but OPEGA did a report and analysis of the beverage container law in 2018, and their final report is linked here as well. And the only thing I would note that they talk about a couple of different handling fees that the redemption centers get based on where the bottle came from. And those fees have since been updated after that report. So it looks like to me, as far as I can read from the statute, that if you're a redemption center, you get 4.5 cents for all the containers you collect, as long as they're actually returnable in Maine. You wouldn't get that money if it was, in fact, somebody was driving into Maine from Massachusetts and brought all their bottles with them. That's a Massachusetts bottle. You don't get the money for that. So the questions or the issue raised in the testimony, however, was under Senator Miramont's bill, who would be responsible for compliance with Maine's beverage container laws, because he newly adds that requirement to direct shipment. It doesn't apply now. And there were questions about whether out-of-state entities, including small out-of-state wineries whose direct ship products are exempt currently, would have the ability to comply with Maine's law. And then as far as Senator Stewart's proposals, because he doesn't add the beverage container law requirement, people were asking questions about what financial impact that might have on Maine's redemption centers. As far as tax compliance, the Bureau expressed concerns regarding the state's ability to collect excise taxes on wine shipments under Senator Miramont's bill, and the Bureau suggested enhancing the reporter requirements actually in current law and any of the proposals before you. They mentioned that they believe there are shipments coming into Maine now that are not compliant and where excise tax isn't being paid. And so they hoped that there could be some beefing up of the statutory language to maybe help them ensure compliance in the future. There were also some concerns that the Bureau had about Senator Miramont's bill, which expands to retailers and wholesalers the ability to direct ship wine. They indicated that there would be additional staff necessary to ensure compliance, and I listed the number of staff they mentioned at the public hearing here on the bill analysis. In addition, they noted that they might require additional funding for a web-based licensing and reporting system specific to direct shippers if you go with that proposal. As far as Senator Stewart's proposal to allow direct shipment of spirits, the Bureau expressed concern with the potential for an unlevel playing field and negative impact on spirits revenues to the state if direct shippers are authorized to sell spirits to Maine customers at any price that they choose and in any bottle format, while agency liquor stores and in-state distilleries that sell their products at their manufacturing facilities would be subject to the state's listing, pricing, and distribution system. The Bureau also noted that the current warehousing and distribution contract for spirits will expire in 3 years, and a new contract is estimated to be awarded in July 2024. And then there were many questions at the public hearing about whether the current laws provisions that are carried forward in each of the proposals before you that involve preventing youth access. There were questions whether those were sufficient. The Bureau did propose, if you go forward with Senator Miramont's bill, as I mentioned before, they wanted some enhanced reporting requirements to ensure that all excise taxes are collected. So they suggested requiring common carriers to report all of the direct shipments of wine to customers in the state. I'm sure if you went with Senator Stewart's proposal, they would also want to add in spirits and malt liquor as well, so that the common carriers have to report, and then they could then compare those reports to the reports by the direct shippers themselves. The National Association of Wine Retailers actually submitted testimony agreeing with that recommendation. They actually independently made it. The Maine Beer and Wine Distributors Association did not support Senator Miramont's bill and instead asked that you convene a stakeholders group to review the current wine direct shipper law and how many licenses are being issued and how many wine labels are being shipped under it, how much actual wine is being shipped and whether the excise taxes are being collected, and whether to add the common carrier reporting requirement required or proposed by the Bureau. Obviously, the sponsor of LD 1358 proposed an amendment, so we went through it before. In addition, if you do go forward with that proposal to add spirits through 1358, the Bureau proposed amending that bill either to limit direct shipper license to small distilleries, either in-state or out-of-state, that have a clearly defined maximum production amount. That was one way that they thought you could minimize the impact on the spirits business if that's of interest to you, or they said you could instead convene a stakeholder group. So that's similar to the proposal for Senator Miramont's bill that others raised. And just to talk about the potential impact of adding direct shipment of spirits to the state spirits business, and maybe carrying over the bill and implementing the recommendations or awaiting the recommendations later. The Distilled Spirits Council of the U.S. also suggested some amendments to Senator Stewart's spirits bill, and they thought that it might be helpful to change the way that the tax rate's calculated on direct ship spirits, to limit direct ship spirits to products that are not currently listed for retail sale in Maine, so only other products that consumers can get a hold of, and adjusting the maximum per customer per year direct shipping amount. They didn't have that amendment ready at the public hearing, so I don't know exactly how they changed the tax rates or the maximum amounts, but that was their suggestion. There's another group of distilled spirits distilleries, and that's the American Distilled Spirits Alliance. I'm not actually sure of the relationship between the two, but they also have proposed amendments to Senator Stewart's bill, and they suggested clarifying that the out-of-state manufacturer of spirits has to hold a valid permit under the Federal Alcohol Administration Act and operate as the brand owner or its authorized agent. There is a requirement in the bill, and it's copied over from the current law about wine, that you do have to have a federal permit. So I don't exactly know why they want to add that brand owner or authorized agent language, but that might be something to explore. They also proposed allowing distilleries to use fulfillment centers and not actually ship the products themselves directly to the customers, but to use a vendor for that purpose. They did want to propose that you require that the spirits be sold at the retail price for spirits in Maine. To clarify, they thought it was ambiguous, and they thought it would be worth clarifying whether the spirits that are not currently listed for sale in Maine may be direct shipped. That was actually an ambiguity I didn't understand with the bill as well. And they, instead of imposing the $500 penalty the first time somebody direct ships to a Maine customer without a license, they proposed that the Bureau issue a cease and desist notice to that distillery, and only after that notice was sent, if a second or subsequent shipment was made, then the violation penalties would apply. The Maine Grocers and Food Producers Association, for either of these bills, wanted to add some additional restrictions on direct shipments. So they wanted to limit all direct shipments to products not currently sold in the state at their retail locations, and perhaps also lowering the amount that could be shipped to any one customer to what they called a true sampling of a new product. They also thought you should prohibit sales of products at any price lower than the current retail price in Maine. And they thought you should impose a premium or a direct shipper's fee on all of those products. Alternatively, they agreed with other proposals you heard about having a stakeholders group. I did want to just remind you about your recent legislation that passed out of this committee and then through the legislature, which was to clarify that Maine manufacturers, if they're authorized in another state and follow that other state's laws, can directly ship their products to out-of-state customers. I bring that up to just emphasize that these proposals before you are all about direct shipping into the state of Maine and within the state of Maine to Maine customers. So it's not about going out of state. For comparison purposes, according to the National Conference of State Legislatures, as of last summer, 46 states allow wineries to direct ship their products, 6 states allow distilleries to direct ship their products, and 8 states allow breweries to direct ship their products. In addition, 2 states, Connecticut and New Hampshire, also permit retailers to obtain licenses for direct shipment of certain liquor products to the individuals located in those states. But the National Conference of State Legislatures didn't report that any states authorize wholesalers to obtain a direct shipment license as proposed in Senator Miramont's bill. I would point out that the list of states that NCSL published is slightly different, for example, than the list that Avalera, which came and testified and said that it keeps lists of all of these states. They have slightly different lists, but they work out to about the same number of states for each category. If you directed our office to in the future, we could absolutely look at each of the state laws. It could just be that as amendments are made to different state laws, that the numbers go up and down over time, but they are about that ratio, that almost all states allow wineries and some states allow the other types of manufacturers to ship their products. I did think that in Senator Stewart's bill, although it does provide, well, I'll back up. Under current law, the State Liquor and Lottery Commission determines which spirits items may be listed for sale in the state. And it wasn't clear to me if that listing is required to direct ship a product to Maine under this bill. And either way, I think it just is worth specifying in the bill if you want to move forward with it. In addition, I didn't think that the intent of that bill was to require that the retail price set by the State Liquor and Lottery Commission apply to those spirits products. But if that is true, I think that could be clarified. And if it's not true, that absolutely needs to be clarified. And then just as a sort of a overall suggestion, these direct shipment bills are all exceptions to the general rules that only this state can import spirits into Maine and then send them through the state system. And I mean, there are certain carve outs for like religious entities can bring in spirits for religious ceremonies and things like that. But generally it's only the state. And I think it would be worth looking through the importation and transportation laws and making sure you have cross references to the new authority, either for distilleries or for breweries that are in Senator Stewart's proposals, because they are in different sections of statute, and you need to make sure that all the cross references work out so that there isn't a conflict within current law about whether these products can be shipped to Maine.
Great, thank you, Janet. So we've got two bills here. And I appreciate the breakdown of what's in each one, as they both kind of apply to direct shipping of various items. Any questions at this time for Janet on the analysis? I guess we can take them one at a time. So I guess LD 1093, I think is a pretty broad change, as we heard in the public hearing, allowing out-of-state and in-state retailers plus out-of-state and in-state wholesalers caused a lot of concerns from people within the Maine industry, Maine retailers. Almost a near unanimous concern about that. So I'd be hesitant to move forward with the model in 1093. I don't know where everybody else is on that one, but those are some initial thoughts from me. Okay, Representative Chiazzo.
Yeah, thank you, Mr. Chair. Yeah, I would agree. I mean, I think I know the concerns were initially centered around the return bills, and but I think, you know, expanding and already doubling the amount of wine that can be shipped, I think might be a little problematic too, especially for some of the local stores. I think it's something that I would have a hard time supporting as well. So I would actually like to move ought not to pass on, which one is this? This is 1093. My apologies, 1093. Yeah.
Second.
Okay, motion of ought not to pass by Representative Kinney, Representative Chiazzo, seconded by Representative Kinney on LD 1093. Any further discussion on this one at this time? Okay, seeing none. 5, 6, okay, we've got enough people, so we'll proceed to a roll call vote. Karen, please.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 9 in favor of the motion, 0 opposed to the motion, and 4 members absent, Mr. Chair.
Great, thank you, Karen. So the ought not to pass carries unanimously of those present. Okay, so regarding LD 1358, that one is another direct shipment of spirits bill from Senator Stewart. I know he offered an amendment at the public hearing to add in malt liquor, something which I think a lot of industries, or at least some of the craft industries, were supportive of. And I believe we have that, as Janet indicated there. Any thoughts on LD 1358? Representative Chiazzo.
Thank you, Mr. Chair. Yeah, I appreciate the amendment from the sponsor. Not sure if the bill is presented, even with the amendment, is quite ready for prime time yet, but I am happy to give them some more time, the stakeholders group more time to work out the details of it. I think there sounds like there might be some areas they can coalesce around. I'm certainly happy to explore that, but if there are other motions out there that want to be made, then I'm happy to defer as well.
Thank you, Representative. I'll agree with you. I think as original bill, but I think there may be some potential solutions. But I think it does need a lot more time, especially as we get into some of the other more technical things like tax rates and bottle redemption types of issues. Any other question? Representative Chiazzo?
Well, if that's the case, then I would like to move that we carry over 1358.
Okay, we have a motion to carry over by Representative Chiazzo, seconded by Representative Riley, I think. Is that? Yep. Okay. And I think in talking with, I know a lot of the stakeholders kind of brought that up in the public hearing, that perhaps not only just a carryover, but we put the stakeholders together and they try to kind of hash out a solution over the summer, and maybe we can find a way to make something like this work. Any other discussion at this time? Okay, seeing none, the motion before us is to carry this bill over and have a stakeholder group, I guess, meet. So we'll move to a roll call vote. Karen, please.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 9 in favor of the motion, 0 opposed to the motion, and 4 members absent, Mr. Chair.
Thank you, Karen. So it's unanimous of those present, and we'll add that to the carryover list of bills. And we'll work with Bablo to try to assemble a stakeholder group that covers all segments of the industry. Great. So I guess next we can go to LD 1272, an act to eliminate limits on the number of taste testing events for beer, wine, and spirits.
So this bill amends several provisions of Title 28A that govern taste testing of spirits, wine, and malt liquor by off-premises retailers to provide that each off-premises retailer may conduct an unlimited number of taste testing events per month. Under current law, each licensed off-premises retailer may conduct up to 15 taste testing events per month, regardless of the type of liquor provided at the event. For some background information, there are some conditions that apply to taste testing events that are conducted by the retailers. First of all, an off-premises retailer may only offer samples of the type of liquor that's authorized to sell under its off-premises license. So for example, if you're not an agency liquor store that's allowed to sell spirits, you can't conduct as a retailer a spirits taste testing event. In addition, each off-premises retailer must stock at least 100 different types or codes or units. They use different phrases, but I think it's different codes of spirits, wine, or malt liquor to offer samples of that type of liquor at the taste testing event. There are some maximum amounts for samples that can be offered to a single customer. So for spirits, depending on the proof, you still have 3 servings, but your serving size changes if it's a higher proof of spirits. For wine, depending on the percentage of alcohol by volume, you can either have 5 ounces total of samples or only 3 ounces total of samples. And then again, for malt liquor, depending on the amount of alcohol by volume, it changes how much you can provide as a total amount of samples to any one customer. And they're all laid out there in the chart. All of those provisions of law specifically state that samples may not be served to anyone who's visibly intoxicated or if they're not 21 years of age or older. In addition, each off-premises retailer must request permission from the Bureau to conduct the taste testing event. They're allowed to combine all of their requests for a single calendar month into one form, but they must list the date and time of each proposed event as well as the liquor product or products that will be offered. The request has to indicate whether a licensed sales representative will be providing the samples, and if so, they have to verify that that sales representative successfully completed an alcohol server education course. The retailers are not allowed to charge any fees for the samples. They can't conduct taste testing in a municipality that doesn't allow off-premises and on-premise sales of liquor. They also have to post a sign at the store entrance discussing the fact that there is a taste testing event unless it's going to be invitation only in a private event, in which case they don't need to post the sign. Just so that you know, in the 129th legislature, this committee passed out a bill that changed the number of taste testing events that each off-premises retailer could hold per month from a maximum of 3 taste testing events, which at that time, it could only be a spirits taste testing event or a wine taste testing event or a malt liquor taste testing event. You couldn't offer more than one type at the same event. And there was a total of 3 that you could offer as an off-premises retailer per month. So in the 129th legislature, that was changed to the way the current law reads, which is 15 events per month of any type of liquor, and you could offer more than one type of liquor at the same time.
Great, thank you, Janet. Any questions? I guess, Janet, just a question on Bureau approval. So even if we were to move ahead with the bill, any of these taste testing events would still require, under current law, approval, right, from the Bureau?
Yes, that provision of each of the statutes isn't touched, so you'd still have to submit a request. You could still combine all your requests for 1 month on one form, but you would have to list the date, the time, the products that would be sold. all of those requirements would apply.
Okay, thank you.
All of the requirements I actually talked about, other than the number of events, everything else is not changed.
Okay, great, thanks. Representative McCray.
Thank you, Mr. Chair. I had the same question which Janet just answered. So I like this providing more flexibility and would like to make a motion ought to pass.
Okay, motion of ought to pass.
Second.
Is that Topeka? Okay, great. By Representative McCray, seconded by Representative Supika. Any further discussion? And that this would be straight out to pass, Representative McCray, unless there's a fiscal notice, then it would be an ought to pass as amended.
Yes.
Okay. Yeah, I think. I think this gives some flexibility. It makes me more comfortable, given that the Bureau has to approve and know that these are taking place, that it happens. But I think especially for those of us in seasonal tourist areas, this may be something you want to use more frequently during busy times and less frequently during the off season. So I think it does give some flexibility. Representative Kinney.
Thank you, Mr. Chair. I'm guessing that there might be a minor fiscal note, but that doesn't necessarily need to have an ought to pass as amended, right? Because where you said where the department has to approve the tasting events, there's probably going to be a slight cost there.
Right. Yeah, I think there could be. It looks like not yet determined, but if they do have to put something on, then I guess we can do pending fiscal or whatever. Yeah. Any other thoughts on this one? Discussion? Okay, seeing none. 1, 2, 3. Okay. But we do have 7. All right, my bad. It's hard to count. It's so much easier to count in the committee room. All right, we do have a motion before us, which is ought to pass with amendment if a fiscal note comes. And we will proceed to a roll call. Karen, please.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. We'll come back to Senator Farren. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. Senator Farren. Senator Farren, absent.
I know he's got like 3 committees going right now.
8 in favor of the motion, 0 opposed to the motion, and 5 members absent, Mr. Chair.
Great. Thank you, Karen. So unanimous of those present. And again, I'll just remind people that anyone absent only has till noon the next business day now because of the memo from the presiding officers. So that'll be Monday at noon, it looks like now, for anyone absent. Great, so we'll close the work session on LD 1272. Next, let's go to LD 591.
Sorry, technical difficulties.
No problem. We have a couple questions anyway. Representative Chiazzo.
Thanks, Mr. Chair. I believe we've already done the analysis on this. I don't think anything has changed. I certainly, as the sponsor, I don't have any amendments or anything to bring. I would just make the plea for the committee that, you know, I'm certainly hearing in my community this would be helpful. Initially, I thought it was just a kind of a routine kind of thing, but since the bill was put out there and advertised, I have had some interest in our community, and I believe I've heard from several other communities on the list of those affected by this bill that they've been very positive. I know there were some concerns for the highest tier group, and I certainly will let others speak to that. But I hope to get your support moving this forward. I think it's a great opportunity for local businesses to expand. There's no guarantee who's going to get these licenses. We're not changing the rules on applications or the requirements or anything in terms of locations that need to be met. Bablo still is the deciding authority over that. Their rules are still in place. Really, the only thing we are doing is increasing the number of licenses by 1. And I think it's a total of 6 altogether that are possibly affected by this. And that certainly does not put us in any kind of conflict or requirement on the liquor contract as well. So we don't need to go back in and have to reevaluate or renegotiate anything there. So hoping to get your support, and we'll see where the debate goes.
Representative Wood and then Kinney.
Thank you, Mr. Chair. I just wanted to say at the last work session, I did need more time. I had some questions in Portland here in the top tier about how locations were selected. And I did have some conversations with a couple of people at Bablo, and I'm comfortable now with the process they go through to look at where new licensees are located. So I'm good to go on this.
Okay, Representative Kinney.
Thank you, Mr. Chair. I've had concerns because I was here for the 129th when we increased Portland to its own category, which I guess they really already were. They were the only ones in the 45,000 to 60,000, or 45,001. So they increased just a couple of years ago. And I guess I know that there are still people in that area that are concerned about adding yet another competition piece. I guess and the other thing that I have concerns with, we don't have census data, so as of yet, so increasing on 2010 census data, I have concerns, and I don't think I'll be supporting this bill at this time. Thank you.
Any?
Oops.
Oh,
hit the wrong button.
I do that all day. Representative Supika.
Thank you. I just wanted to say that I will be supporting this bill. I think it's good for businesses. It's good for Bangor, because that's who I'm representing. I think that I've heard from local businesses that they're excited to have an opportunity to apply for this and to really kind of get more happening, especially in the downtown area. People are looking to, as this could be an opportunity for them. So I will be supporting it. So thank you.
Representative Wood.
Thank you, Mr. Chair. I remembered another issue that I had at our last work session, but in talking with Bablo, and I don't have the numbers right in front of me, but if you look at each of the population tiers and look at the ratio of agency stores versus population, I think that if you look at Portland, we actually have one of the highest ratios, and I'm comfortable that there is room for more. My main concern was about location, and as I said before, I'm comfortable with the process for locating new stores. Thank you.
Thanks. And I guess for me, I think that as long as we don't, violate or the provision of the liquor contract, where if there's over 5% increase in stores in a year that we may have to reopen a negotiation, then I'm fine with doing it. Representative Corey.
Sorry. Thank you, Mr. Chair. I'm uncomfortable with the increase in the top tier, the 11 going to 12 in a town, over 60,000. It's so funny because, with all of these, different tiers, we barely have any, main towns that would even enter that sort of letter D tier at 20,000 to 30,000. I'm not sure what the population of Scarborough is. Representative Chiazzo had talked about his community. I think that my community, Wyndham, is probably, are getting kind of near that other side. I haven't sized in terms of population over 20,000, but I haven't had a chance to reach out to my local sort of liquor stores to see how they feel about this. But I know right now I'm uncomfortable with, increasing the top tier, especially where I don't think that there's been huge amounts of population growth in that city, only because I think that they've run out of room being pushed out into me and Representative Chiazzo's communities. Thank you.
Great. Representative Chiazzo.
Thank you, Mr. Chair. Yeah, I understand Representative Corey's concerns. We're still operating under the 2010 census, and when I talked to Director Minio at Bablo about, do they do the interim census? They do interim snapshots, I think, like every 2 years. They said no, they're fixed on the 2010s at the hard census number. So, right now, I think according to the 2010 census, I think Scarborough is high 18,000s, low 19,000s. It's clear it's going to change with the new census. I think, I obviously can't speak to Wyndham, but I think Southern Maine as a whole is going to see some increases. I don't know by how much, but just looking at voting numbers, number of registered voters in towns, I think we'll see some impact. The reason I didn't want to necessarily was my initial thought was to wait for that. If it happens, great. If it doesn't, then that's okay too. It's really just after talking to the commissioner, they only approve these at certain intervals during the year. I think it's either in June or July, and then again in January. So I wanted to try to make sure that we capitalized. If somebody was going to take advantage, they can capitalize on that summer market. And to do that, because it's not an emergency, we'd have to get it in, get it passed, get it into effect for January so they could apply for July. If we had to wait, they could literally take another whole year or more out of that cycle. So that was the intent of moving it forward and not just waiting for the census data to come up.
Okay. Representative Kinney.
Thank you, Mr. Chair. So I guess one of my questions, you mentioned that Scarborough is one of the towns looking to try to increase, yet at where they are in that 15,001 to 20,000, there's no increase proposed as of right now. But if the census that comes out at the end of the year, if the federal census gets it to us at some point, and they jump to the next one, they'll automatically add one store at that point. I guess is but if they don't go over that 20,000 threshold, they stay where they are regardless, the way the bill is written. So I guess that's, and again, I'm still concerned about the top tiers because, as we said, we did increase and created that 60,000 tier and gave them one more than the 45,001 to 60,000. And it's my understanding there's no one in that group right now. And then the concerns I'm hearing are maybe in that 20,000 to 30,000 group might want to increase. I guess maybe if we only increased a smaller area, I might be willing to do this.
Representative Chiazzo.
Yeah, thank you, Mr. Chair. And I appreciate that, Representative Kinney. You're right. It wouldn't affect Scarborough immediately right now, but my belief is I'm fairly confident Scarborough. I can't speak to the other areas, of course, but I'm pretty confident Scarborough is going to be into that next tier with the next census data. So what this does is it in essence, from my local perspective, it just allows them to start that paperwork process earlier to be up and running sooner. You know, there are other communities out there, and the reason I didn't want to just limit it to Scarborough is there are other communities I think that could benefit from this, and I certainly have heard from a number of them. So it's the constant balancing act of not impacting the revenue, the liquor contract. So we open it up to too many groups, we have to go back and renegotiate, but allowing those communities that can support that growth and can support that extra licensing to be able to try and take advantage of that. So that was the intent of kind of capping it at that number. I realized it didn't, if I dropped it down to a lower level, it would have certainly broadened that net, and we would have run the risk of having to renegotiate the liquor contract at that point. It wouldn't have been worth it for sure. Does that make sense?
Okay. Any further discussion on this topic, or is anyone prepared to make a motion? Representative Corey.
Thank you, Mr. Chair. The one that I'm honestly most uncomfortable with is letter A, and if that goes up to 12, then I'm not willing to support an ought to pass motion. But if we get rid of letter A, I'm willing to do an ought to pass as amended. Where I'm at. Thanks.
Okay. Thoughts on that, or Representative Chiazzo?
Thank you, Mr. Chair. I have no opposition to that. But I don't know. You know, I know Representative Wood happens to be representing Portland, and I have heard from other people in Portland that there is support for this on some level. It's certainly not across the board, and that's completely understandable. So I'm happy to entertain that, but I would prefer to kind of leave it as it is now, and unless Representative Wood has concerns about that as well. But I'm happy to entertain that amendment if desired.
Representative Wood.
Thanks, Mr. Chair. You know, as I said before, when I look at the ratios, Portland has one store per almost 6,000 people. And in this last incident where somebody was looking to put an agency store on the Forest Avenue corridor, if you're familiar with Portland, there's already quite a bit there, and they were denied. And those same people then went to another part of town that didn't have any agency stores. So I think, and they were granted a store. I think Portland's big enough, and different parts of the city are now starting to come alive. Getting agency stores out into those other neighborhoods is a good thing. And I just keep looking at, you know, the number of people per store. Portland still has the greatest population to cover. So I'm not in favor of amending it.
Okay. So at the moment, we still do not have a motion, just so people know.
I'll make a motion of ought to pass.
Okay.
Second.
All right, so we have a motion of ought to pass from Representative Supika and seconded by Representative Riley. Representative Corey.
Thank you, Mr. Chair. I'm just going to say I've never had a problem finding liquor when I go into Portland. Like, I've never felt like there is this liquor shortage where I'm like, oh my God, where am I going to get my booze today? I'm just sorry.
And that is kind of the interesting thing, is that when it comes to beer and wine, you can find it everywhere, but it does get more difficult with spirits. And I think there have been bills to change the municipal based way of awarding. But obviously I think that's something we'll have the larger conversation with the next liquor contract. So Representative Wood, did you have a question, or was that from before? Okay. Representative Chiazzo.
Thank you, Mr. Chair. And again, I don't want to beat this in the ground. I appreciate what Representative Corey is. I grew up there, and you know, the old adage was you couldn't swing a dead cat without hitting a local convenience store, right? I think it's a question of convenience though, right? If you're in the neighborhood, if I want something specialized, I have to travel into Portland to go get it at certain stores that carry certain things. Whereas, if there's something that's a little more, standard, I can go to a local place or I can have them special order it and go there. So I think again, if I thought it was going to impact, retail sales to a point where it would start cannibalizing some of the local markets, then I would agree with you 100%. I think to Representative Wood's point, there's enough market out there and enough demand out there, I think, to support the growth. I guess if we want to play the environmental card, I'd rather drive 10 miles to get something than 15 or 20 to get something that I want. So, but I'll leave it at that. I'll defer. I'll give you the point for sure.
Representative Corey.
So I can honestly say that, I think 20 years ago, this could have been a problem in Portland. I think prior to, us sort of opening up more liquor stores. I used to live on the peninsula, up on the West End. And we used to joke around, me and my friends, that we were driving to the New Hampshire liquor store if we were driving, under the highway and over to RSVP. But I just don't think it's that hard anymore. But okay, convenience. Thanks.
All right. Seeing no further debate. Okay, we have 7 here. So seeing no further debate, we will proceed to a roll call vote. And the motion before us is ought to pass. And Janet, was there a fiscal note on this, or is it?
We don't have it yet, I don't believe.
Okay.
I haven't seen one anyway. Great. I can actually double check really fast.
And so I would think Representative Supika, you'd be good if it gets amended eventually with a fiscal note in your motion.
Yeah, it's still not yet determined.
Okay. All right, so the motions ought to pass pending the fiscal note. And Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. I'll come back to Representative Kinney. Representative Harrington. Representative Harrington, absent. Representative Corey.
No.
Representative Corey, no. Representative Dolliff. Representative Dolliff, absent. Representative Kinney.
Is this ought to pass?
Yes.
Yeah, no.
Representative Kinney, no. 6 in favor of the motion, 2 opposed to the motion, and 4 members absent, Mr. Chair.
Thank you, Karen. And
Oops, I'm sorry, 5 members absent, Mr. Chair.
okay,
I apologize.
that's fine. You're way better at counting these than I am. It's hard to do it on the squares. So for the minority report, Representative Kinney or Representative Corey?
I will be ought not to pass.
Okay.
I'll be ought to pass as amended, removing that first increase, letter A, and just keeping that at 11.
Okay. All right, so with that, we'll close the work session on LD 591. We don't have Senator Farren at the moment, so we can skip over his bill until he gets back from his committee. So I think we can move to LD 930, Janet. Oh, actually, Senator Farren's back. Do you want to do your bill, Senator? Or you gotta,
Sure.
I know you're in 3 committees at once, so.
No, it's all good. I got
Okay.
2 down. I think I'm back.
All right, great. And then we can send the liquor agencies. They don't have to sit through all of our other hearings. So yeah, let's open the work session on LD 1492.
So LD 1492 is an act to provide more choice for Maine consumers in the purchase of spirits from Senator Farren. This bill changes the definition of low alcohol spirits product to include products with up to 15% alcohol by volume as compared to the 8% limit in current law. The bill also makes several other changes to the laws governing low alcohol spirits. There you go. So there was discussion in the testimony that the essence of the bill is the change in the definition of low alcohol spirits product, but the bill also involves a lot of other changes about who can distribute it, et cetera, and so forth. And there was a suggestion to maybe compare to what is going on in the errors bill that you just agreed to carry over. So that's why I put that in this chart, just based on the testimony we received. So I'm not trying to overcomplicate it. I'm just good at complicating it. So the definition of low alcohol spirits product under current law, as stated, is less than or equal to 8% of alcohol by volume if the product contains spirits. Under Senator Farren's proposal, that would go up to 15%. The key change is by increasing the limit. You then take that group of products that include spirits that have between 8 and 15%, you take them out of the definition of spirits and put them into low alcohol spirits. And that matters because you then take them out of the control state model and put them into the wine and malt liquor model of distribution and pricing, et cetera, and so forth. And then one thing that the errors bill does is it clarifies that if you have less than 0.5% of alcohol, you're not regulated in Maine generally. So the errors bill clarifies in the definition of low alcohol spirits product that it doesn't include any product that has less than 0.5%. So that's just something to consider if you want to move forward with this bill. Maybe you'd want to add that. It's entirely up to you. As far as who may manufacture these products, under current law, it's important to note that the definition of fortified wine, there's a couple of definitions, but one of those definitions is if it's a, I'm just gonna click on it because it's easier. This is the handout I gave you for the definitions earlier. So wine is a product that's, one of the definitions is a mixture of wine and spirits as long as the product has more wine than spirits, and it has to have less than 24% alcohol by volume overall. So if you're a low alcohol spirits product, meaning you have less than 8% of alcohol by volume under current law, and you are a mixture of wine and spirits, then you are by definition a type of fortified wine under current law. Why did I confuse you by saying that? Well, it's actually very important because if you're asking who can manufacture these products, if the low alcohol spirits product is that mixture of wine and spirits, and it's less than 8% alcohol by volume or equal to 8%, then it's considered fortified wine. And fortified wine is something that a winery may manufacture under current law. So that subset of low alcohol spirits, we're clear, they're manufactured by wineries, but current law does not indicate who produces all of the other types of low alcohol spirits products. So under Senator Farren's bill, there's a line of the bill that adds the authority for all in-state and out-of-state manufacturers, any type of liquor, to produce low alcohol spirits products. So as I read that line of the bill, that would include breweries, wineries, distilleries, rectifiers, and bottlers. Just by contrast, the errors bill took a slightly different approach, which is entirely up to you how you want to move forward. So under that bill, because it was already clear that wineries can produce fortified wine, which is mixtures of alcohol and mixtures of spirits and wine that fall within the low alcohol spirits product definition. It also added clear authority for breweries and small breweries and tenant breweries to make low alcohol spirits products as long as those products consist of malt liquor to which spirits have been added. It also clarified that distilleries can produce these products and that rectifiers can produce these products. It also further clarified in that bill that low alcohol spirits products that are produced by a small winery, a small distillery, and a small brewery count toward their maximum gallon or barrel production caps. So to have that small category license, you have to be under a certain amount. It's 50,000 gallons, for example, for a distillery. It's mentioned later in the bill analysis, but basically all the low alcohol spirits products count toward that cap. So that's just the alternative approach. It's up to you which one to take. I would point out that the way that the bill is drafted now, I think you need to take out the authority for out-of-state manufacturers to produce low alcohol spirits products, because that's not something Maine has control over, what they do in that state and what they manufacture, but that's up to you. I would also suggest maybe amending the bill to be clear that you only mean to talk about licensed in-state manufacturers. You might want to be clear about whether the brewery's low alcohol spirits have to contain malt liquor, and whether the winery's low alcohol spirits have to contain wine, which was the approach in the other bill, but that's up to you. I didn't mean to add 2 question marks. It wasn't like I meant to emphasize that. I just made a typo. And then also, I'm glad somebody's laughing. Thank you, Senator Barron. And then the other question I had was whether the products would count toward the small manufacturers' production caps. Again, entirely up to you. Then the question is who may import these products to Maine? Again, because certain subset of low alcohol spirits products are considered fortified wine, it's clear that out-of-state manufacturers or wholesalers of malt liquor and wine that have a certificate of approval. Remember, I mentioned earlier today, this certificate of approval is your authority to export your products into Maine, or from our perspective, to have your products imported into our state. So if you're an out-of-state manufacturer or wholesaler of malt liquor and wine, then you can import low alcohol spirits products that contain wine because they're fortified wine. But it's not clear under our current law who can import the other low alcohol spirits products. This is an area, because there are many areas, despite the fact that it's a 100-page bill now, and it used to be a 110-page bill in the last session, there are many areas of Title 28A that were not clarified through that bill, and this is one of them. So this wasn't touched in the errors bill. Senator Farron's proposal would say that if an out-of-state manufacturer of anything, spirits, wine, or malt liquor, or an out-of-state distributor or wholesaler of spirits, wine, or malt liquor, if it has a certificate of approval to import things into Maine, then it would be able to import all types of low alcohol spirits products. My only technical issue with this, and this is probably just a nightmare left over from reading Title 28A far too many times for anyone human to reasonably do, is I wouldn't put this provision where it is currently located in the bill. That's just, it's not a policy change, it's just a drafting request to maybe move it. Then the next question is who may distribute these products. This is another thing that sort of seems to be the heart of the bill. So under current law, again, if you're a wholesaler licensed to distribute wine, then you can distribute a low alcohol spirits product that meets the definition of fortified wine. Current law doesn't indicate who can distribute the other types of low alcohol spirits products. I would note, however, that if you look at the definition of spirits in the law, spirits specifically excludes low alcohol spirits products. So my interpretation of current law is these products should not be subject to the state spirits pricing and distribution system if they're currently sold in Maine and they're less than 8% of spirits. So if you look at the approach in the errors bill, which is on the far right, what that subcommittee of this committee decided to do and propose was that all low alcohol spirits products could be distributed by any in-state wholesaler of wine, just to follow kind of the current model, and they would just expand it from just fortified wine to all types of low alcohol spirits products. So that was that proposal from that subcommittee. Senator Farron's proposal is that any low alcohol spirits product that's imported by an out-of-state manufacturer of malt liquor or wine would be distributed by a malt liquor or wine wholesaler within the state. By contrast, if it's a low alcohol spirits product that's imported into the state from an out-of-state manufacturer, out-of-state wholesaler of spirits, there's a two-part test. You first look at whether that spirits product was distributed in Maine before the effective date of the bill. If so, then whatever that distribution system was in that distribution model, you would continue with that model. Then you'd say, well, okay, we now have a spirits product that has never been in Maine and it wasn't before this bill became effective. What do we do? And the answer under Senator Farron's proposal is that it would have to be distributed either by the wholesalers, which are malt liquor and wine wholesalers, or by the language in there is reseller agent. I think that's a drafting error. I think they mean reselling agent, or perhaps they mean the state spirits distribution system, which I would write slightly differently. But as determined by BABLO would make the choice of which distribution system it went through, if it's imported by a spirits manufacturer and hasn't been sold in Maine before. So my first question was, if you look, these two categories talk about who imports the product. There's nothing about what happens if the product was made in Maine. So that would be my first question for you, who would distribute those products? My second question, just the way it's drafted, it just says it's distributed by a wholesaler. You should probably limit that to licensed wholesalers, but that's up to you. And then I would also, just as I mentioned, maybe replace the way the language talks about the Bureau's determination to make it clear that they're just deciding between the wholesale model and then the state spirits distribution system, which is not just reselling agents, because reselling agents sell to on-premises retailers, and then the state contractor sells to the agency liquor stores, who are reselling agents as well. And then, although it's not raised in the bill directly, it is implicated by the bill, who can sell these products at retail. Current law specifically says that all low alcohol spirits products can be sold by any licensed on or off-premises retailer of wine. That's not changed in the bill, and it's not changed in the errors bill either. So as I mentioned, what's the effect of amending the definition of the low alcohol spirits product? So if you remember, we talked about earlier this year, there's a control state model for spirit sales in Maine. The state establishes the wholesale and retail price. The state selected contractor provides all of the warehousing and distribution services in the state. Only the statutorily limited number of agency liquor stores. I promise I didn't write that knowing you would do 591 right before this, but now you're intimately familiar with that. Only those agency liquor stores can sell spirits to customers for off-premises consumption, and only agency liquor stores that are licensed as reselling agents can sell spirits to on-premises retailers. So by amending the definition of low alcohol spirits product to increase the maximum alcohol by volume to 15%, the bill removes all of those products between 8 and 15% from the control state model, except for the possibility of distribution, which is addressed in the bill. But all the other things about the only sold at agency liquor stores, the state establishing the price, all of that would no longer apply to those products between 8 and 15% if they contain spirits. Then section 2 of the bill, just to maybe discuss it in a different way, about this bifurcated distribution system. I think what it means is if it's a malt liquor or wine manufacturer or importer, it's going to be distributed by the malt liquor or wine wholesaler in Maine. If it's produced or imported by a spirits manufacturer or importer, previously sold in the state, it would be continued to be distributed in the same manner as under current law. Why I'm restating this is that based on what we discussed before, if it's greater than 8% alcohol by volume, it's currently sold in Maine, it's currently being distributed through the state spirits distribution system, because that's how all spirits are distributed. And right now, that over 8% product is considered a spirit. If it wasn't previously sold in Maine, again, the Bureau would be allowed through rulemaking to decide how it would be distributed. I did want to point out that although the actual real life implications of choosing between distribution systems may be real. The statutory implications are not. So what am I trying to say? Testimony at the hearing suggested that if some low alcohol spirits products would have to be distributed through the state's distribution system, then those products would only be sold by agency liquor stores. And as you know, there are a limited number of agency liquor stores allowed in the state. By contrast, if the spirits product, low alcohol spirits product, is distributed by wholesalers of malt liquor or wine, they could make that available at a far greater number of off-premises retail locations that just sell beer and wine. I would note, however, that although the state spirits distribution system may only currently actually physically distribute products to agency liquor stores, the law will still provide that any off-premises retailer of wine can sell any low alcohol spirits product. I don't know how you're going to get it to a non-agency liquor store, but the non-agency liquor store is authorized to sell it. So some technical issues. I did wonder whether the bill intended that the Bureau would determine separately for each new low alcohol spirits product that's imported or manufactured by a spirits importer or manufacturer. Would they decide for each new product whether it's going to go through the wholesale or the state spirits distribution system? Or is the idea that through rulemaking, the Bureau would set up categories? And maybe that's clear enough in the bill, but it was just a question that occurred to me. I also did ask here if you wanted to adopt the errors bill approach of clearly excluding anything that has less than 0.5% of alcohol by volume, since generally it wouldn't be subject to regulation in Maine, but it's just not clearly stated in that definition of low alcohol spirits product, either in current law or in the bill. And then the last thing I asked is about importation and transportation statutes. I alluded to this a little bit more earlier today. But right now, a Maine small winery that manufactures low alcohol spirits products has to purchase the spirits that it's using from a distillery because it doesn't make spirits. Under current law, the small winery may not import spirits for this purpose or transport spirits within the state for this purpose. Except that under current law, a winery may transport more than 4 quarts of spirits within the state if it purchased those from an agency liquor store. So it looks like under current law, you can buy spirits within the state, but you can't import them. The errors bill looked at all of the transportation and importation statutes, which were really had been amended over time. It was kind of difficult to follow, at least for me anyway. And so that comprehensively rewrote all of those. And as part of that comprehensive rewrite and looking at the whole low alcohol spirits product issue, it made it very clear in that proposal anyway, that all breweries, wineries, rectifiers, and bottlers would have the authority to import spirits and cause those spirits to be transported to their facilities for the purposes of producing low alcohol spirits products. So that's just an idea. I hesitate to say this because I know we're being broadcast and recorded. It may be that that's not something you want to touch in this bill because it involves comprehensively rewriting the transportation and importation laws in a whole bunch of other different ways, but it's just so that you know that that is an issue out there for the in-state manufacturers, how they're going to get the spirits. There, we can just pretend I didn't say that.
Thank you, Janet, for that analysis. Any questions from the committee at this time for Janet, or any discussion otherwise? Representative Chiazzo.
Thank you, Mr. Chair. Janet, I just wanted to be clear I understood you correctly. I think you said that if this goes into effect, that non-agency liquor stores can sell spirits up to 15%, or did I mishear that? I don't know how they'll get them, but they're legally able to do that.
Yes.
Okay, all right, thank you.
And that's under current law. It's section 13 of the statute, and it says low alcohol spirits are sold by retailers of wine.
Okay, all right, thank you.
Senator Farron.
So first of all, Janet, thank you so much because you put everything down, everything I was thinking. So thanks. That really good. No, a lot deeper. I was trying to be funny that time. So I think there's a couple things I'd like the committee to consider on this. Obviously, we have some issues, right? The transportation piece, some other things, but I think there's two things. There's technical issues that Janet brought up that I think if there was a will that we could get through, and even if it's not through this vehicle, I think that they need to be addressed in 1643. The ready to mix low package pieces are consumers want them. They want to have access to them and how we go about doing it. But there's also the policy issue, right? And the policy issue goes back to, we talk about having access. And right now, I think it's like 600 agency liquor stores or whatever. We're looking at maybe taking that from the state control and putting it through the distributors. And I don't see this as a loss of income. I think, it's giving consumers more choice, but addressing the fact that there is technical issues that need to be addressed. And we had a follow-up meeting with the director and Anna, and we can bring him in and just talk about it a little bit. But I think the bigger issue is the policy issue. And maybe that's something that needs to be addressed through the errors bill that we're carrying over and talking about some of those. And I'm okay with that if we decide to do that and dispose that way. But I really think that this market and this product that people want to have access to, I think it's worth this committee having discussions about and having it on our radar screen when we're talking about that errors bill. Mr. Chair.
Thank you. Senator, Representative Kinney.
Thank you. I'm dealing with a bunch of things. My father-in-law's being discharged from the hospital today, so I've been communicating with everybody, trying to follow all of this at the same time. But is this going to be like for a single serving, like a bottle of beer type of a thing? So it's a bottle or can of a cocktail, or is this going to be something similar to like what Jose Cuervo does for their margarita mix that it has the tequila in it? And that comes in the big bottles, multiple servings.
Representative, we may want to bring in the director if he may know this product better than me, and he might be able to. Because I think that this is like a line now of drinks that compete directly with the malt beverage seltzer type of thing. So like White Claw, but it's a spirit
and the Truly and things like that. So it would be a single serving type of a product.
I believe
most
so.
likely.
And
yeah.
I think the director. Oh, maybe there's two Greg Minios in our attendees list, so we'll bring in both and see which one hits. But I do think that's one of my concerns, is that we will be raising the alcohol by volume to 15% at retail in one of these drinks. Director, I think that's what you raised. Did you hear the question from?
Yes, I did. And that's exactly what we raised. Yeah, exactly. And we apologize for the two Greg Minios. It's not my avatar. It's Anya. Anyway, yes, that's exactly right. This is mostly about access, public health. The numbers would be about 600 agency liquor stores going to 2,400 plus, so about fourfold. That's exactly right.
And Director, I think, are these primarily, I think to Representative Kinney's questions, are these like a can of beer basically, but it's just a can of a cocktail, like a one serving?
It would be those and the larger formats. If I'm reading the bill correctly, it would be both. And I think I mentioned in my testimony, and I think I mentioned on our call the other day with Senator Farron, that there are the traditional larger formats for the margarita mixes and things like that with alcohol in, obviously, that have been around for a long time. Jose Cuervo makes them and all that. And those would continue and those do well, but that would fall under this measure. But I think the growth potential is in, I'm doing this, the small cans, and a lot of those are 355 milliliters, and they come in 4-packs. So it would be both, to my understanding, but I think the bulk of this moving forward in this exploding subcategory are what I guess I would call the canned cocktails.
Representative Kinney, did you have a follow-up?
Yeah, I guess I'm wondering, and it kind of goes back, I know I said something about this during the public hearing. I wonder about malt beverages that have the higher alcohol content. I certainly go places that, and those are those, I realize they don't fall under spirits, but are they available in cans and bottles for purchase in single serving containers currently with 9-10% alcohol?
Those are format the manufacturer offers them in through the private wholesalers in Maine. There are some cans, I've seen them. I've seen the large format beer bottles, some with the ceramic top on when they're a very unusual type of beer. I've seen ABV on some of those beer products as high as 10 or 11. I don't think it's a large number. I tried to get the number of what that universe looked like, and we couldn't really, we don't track beer by ABV. I couldn't get that. I think it's a small amount. And sure, they're available right now in off-premise stores and beer and wine stores.
Representative Chiazzo.
Thank you, Mr. Chair. Thank you, Director Minio, for coming in this afternoon. I'm kind of getting hung up on the ABV issue, right? Because especially, you know, when this could potentially open up the sale of spirits lower than 15% ABV or less in other retail outlets. I don't know how they get it. That'd be another issue, but legally they could do that. Is there a mechanism? And this might not be, and I think to Senator Farron's point, this might not be the mechanism for this, but is there a possible approach where you could do it by manufacturing type or by product classification, so that we don't have this kind of homogeneous mix of products just strictly by ABV, right? So, I mean, I think to Senator Farron's point, the market is coming out there for these types of products, and they want to come to market and people want them. How can we preserve the spirits market in Maine and still have a viable entry place or spot in the market for those types of products?
That's a great question. My recommendation would be we're all for innovation as well. We would entertain talking to any supplier of a spirits product. Bring them in. Come in, present them for listing through a broker, just like everything else, and we'd be happy to more than likely list it and get it into our 600 plus agency liquor stores.
Okay.
Senator Farron.
Yeah, just so an observation, you know, I kind of see where we're going, which is fine. I said that, but on the ABV piece, and I think Representative Kinney brought this up, right? Yeah, sounds like a lot jumping from 8 to 15%, but let's just as long as we recognize the fact that the malt industry is already in there at 10 or 11 or sometimes 12%. So there's already some of that piece out there. I also said that when Director Minio and I was talking the other day, I just find it ironic being on this committee, right? Where we talk about, we just had the bill before about adding agency liquor stores so that people have better access to more access to booze. We talk about marijuana and adult use. We talk about gambling, and we talk about all the revenue it generates while we're in the middle of a pandemic. And then when we want to talk about competition here, we say, well, we don't feel the public safety piece. Well, that we ought to do that all the time, not just on specific, you know, when the competition piece goes. But anyways, with that being said, we do have a lot of responsibility with that. And I think that we've got to find a way. I know the director just said this, had them come in and present it, whatever. There are competing interests in this with the malt piece, which I love that as well, and the spirits piece. And our job should be to have that policy discussion about how the access is gained and how that does that. And I think we can do that more comprehensive through the ARES bill, as long as we're all open to having that discussion. I'm fine with using that vehicle to keep this discussion moving forward.
And I guess just to add, I mean, one concern that I do have, and I totally understand the high alcohol other products that there are, is that this does make a pretty it makes a pretty significant change from the control model where it goes through all spirits go through the liquors, the state liquor system. But this does carve out this new market and makes it kind of a policy change that this spirit will be a spirit that doesn't go through our state system and will go to the broader market. And as I think, as the director pointed out, it's something that it's a carve out that big beer manufacturers are likely to take advantage of. Director?
Well, I just had one thing to add to that to give you some context, and I think Janet presented to the committee. We did some research on it because I think in testimony from the proponents of the measure, they mentioned 2 or 3 control states. I'll just let you know there's 18 control jurisdictions, and not that we measure ourselves against other control jurisdictions, but to give you some background, 9 of the 18, half of the control jurisdictions have statutes that say that all distilled spirit products, regardless of ABV, go through the control system. That's number 1. There's 4 control states, including Maine, that has an ABV threshold of between 7 and 8. And then there's 3 what I would call outliers. Ohio, just for your information, is 21% ABV, has been that way forever. And that's on all spirit products. Has nothing to do with RTDs or canned cocktails, so that's not new. Idaho, same thing. It's a taxation issue. It's right around 14 or 15%, been like that forever. Iowa is the only control state that we know of in recent years. In 2019, they legislated it from, I think it was 8 to 15 or 14 or 15 for this very same reason that we're discussing right now, for a product in particular that was coming from a large beer manufacturer. Just some background for you.
Yeah. And Director, is there, sorry, yeah, is there, I mean, I guess, is this a move that we're seeing across the country? Or, I mean, I guess it's hard to compare control states to non, but I mean, it seems like these drinks are becoming pretty popular.
Absolutely, there is. And I wouldn't hide behind the fact that it's a movement across the country, control or licensed states, as we call them. And I would say that I've heard rumblings about legislation in the midst in other control states. I know New Hampshire had considered it. I don't think they're going to make a change. They're at 8%. They're right where we are. Yes, this is definitely the new category. This is what it's all about, canned cocktails. It was only malt-based and wine-based, and now it's spirit-based as well.
Thanks. Other questions for the director while we have them up? Seeing none, thank you, Director.
You're welcome.
Further, I guess, discussion on this, or if people are ready to move things, we can do that, whatever the committee's willing to do. Representative Chiazzo.
Thank you, Mr. Chair. I concur with Senator Farron that this is definitely a policy piece that we need to work on. I'm just not convinced this is the right mechanism to do it in. So I'm willing to commit to having those conversations, because I think we're going to need to address it whether we want to or not at some point. But I don't think this is the right vehicle for that. So I'm gonna move ought not to pass on 1492.
Second.
Okay. The motion about not to pass by Representative Chiazzo, seconded by Representative Wood. Any further discussion or debate? Senator Farron.
Yeah, I just want to say, Senator Lucchini, thanks, Senator Chiazzo, for that recognizing the fact that we can have this. I think one of the things that came out of this discussion that we need to talk about, we had that, and the director just hit upon it. He does have the peek behind the curtain and seeing what's going on across the country. And I guess when I looked at this, and I do some traveling around, it was strictly trying to give consumers some more choices to things. And I've been struggling a little bit about why the adamant, opposing to this, and I've heard the public safety piece or whatever, is from the distributor standpoint, is taken out of the state control piece and the large beer manufacturers getting into the market. And I think that's where it comes down, that we have to have the policy decision with those facts about what we're comfortable with. And that's kind of the first time that we know what we're dealing with there is where that perception and what those concerns are. And that's something we can look forward to with 1643.
Any other comments or discussion? Okay, seeing none, seeing no further discussion, we'll proceed to a vote. The motion before us is ought not to pass. And Karen, if you can please do a roll call.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Reluctantly, yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 9 in favor of the motion. Wait a minute. 1, 2, 3, 4, 5, 6, 7, 8, 9.
Yep,
9 in favor. Yeah, 9 in favor of the motion, 0 opposed to the motion, and 4 members absent.
Great, thank you, Karen. So unanimous of those present. Okay, next, I think we'll take up the last liquor bill on our list, which is LD 914. Oh, sorry, Representative Chiazzo.
Thanks, Chair. I just wanted to thank my colleagues on the other side of the aisle for that unanimous vote. I know we didn't agree on that policy, but I think that says a lot to the work that has to go into processing this. So I very much appreciate that, and I just wanted that to go recognize that. I know that was that was very helpful, and it was a great gesture, and I certainly do appreciate that.
Thanks. So we'll move on to LD 9. Oh, sorry. I lost it. 914. If we can.
LD 914, you've had a work session on before. It's an act to meet the state's obligations to pay 55% of education costs. And at the last work session, I believe that Representative Tuttle proposed the idea or floated the idea of maybe conducting a study of liquor and lottery revenues, and that is when you tabled it. But I can go through anything else you want me to.
No, I think that's good, Janet. Thank you. And I forgot we had done one of these before, and I think we were looking to potentially see if something could be done. I'm not aware of anything at this time, and I realize Representative Tuttle's not here. But I think, given the testimony, I'm really not sure what we can do with this liquor money. Really, that's going to have to go through the appropriations process. Even if we were to say that it had to be that way, it would obviously just get taken care of through the budget process with appropriations. So, Representative Chiazzo.
Thank you, Mr. Chair. I guess in keeping with the mantra of the Grim Reaper, I would agree that I think, especially hearing from the department, even if we were to sweep the entire fund into education, it wouldn't it wouldn't get the desired result, and it would upset the cascade. It would upset the flow. Not that even we could control it in the first place. So I appreciate the spirit of the bill. I think we're all working at trying to make that 55% target. I just don't think this is the right mechanism for it. So I'm going to move ought not to pass.
Second.
Okay, motion of ought not to pass by Representative Chiazzo, seconded by Representative Supika. Any further discussion on this one? Okay, seeing none. Seeing no further discussion, we'll proceed to a roll call vote. Karen, if you please, and the motion before us is ought not to pass.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 9 in favor of the motion, 0 opposed to the motion, and 4 members absent, Mr. Chair.
Thank you, Karen. So unanimous of those present. And again, just a reminder, the presiding officers have cut down the time for calling in late votes to the next day at noon, just so people are aware. So I guess that's all the listed liquor bills. We do have that one from this morning. I don't know if people are interested in trying to vote that now, or if they feel comfortable. If not, we can do it at another date. But the one on the municipal votes that was brought to us from the clerks and Bablo on trying to fix that local option issue. Representative McCrate.
Thank you, Mr. Chair. Yeah, I'd be interested in moving to work session and would make that motion.
Okay, so we have a motion to go to work session on LD 1642.
Second.
Okay, by Representative McCrate and seconded by Representative Riley. Thank you. Any discussion on this? Representative Chiazzo.
Thank you, Mr. Chair. I'm definitely interested in doing this. Any work we can save Janet at crunch time towards the end of doing the analysis, then I'm sure it's greatly appreciated. So happy to go to work session for sure.
Okay.
Don't do it for me though. If you need more information, you should get it.
She would never ask us that. Okay, any other discussion? Okay, Karen, can you call the roll, I guess, to move to work session? Just lost my number.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. You're muted, Representative
I hit my space bar. I'm looking at a different screen. Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dalla. Representative Dalla absent. 9 in favor of the motion to go into work session, 0 opposed opposed to the motion, and 4 members absent. Mr.
Right.
Chair.
Thank you, Karen. It's been a long week. Representative Kinney.
Thank you, Mr. Chair. I had written down LD 1642, and that's not right. What LD is this from this morning?
It is 1642. An act to allow affirmation of a local option referendum. I don't, I had trouble finding it online this morning, I'll be honest. But it is posted on our site. That's kind of how I went through it.
Okay, no, I just reread. I read it again. Yeah.
Okay.
I got it now.
I can't
This
remember.
morning was nuts.
I can't remember the numbers of any bills anymore.
I didn't know if you wanted any kind of brief recap from me. Yes,
yeah,
no, maybe.
That would be great, Janet, because I know there was maybe a technical thing that we may want to address.
So I just wanted to remind people that it was very interesting if you have been here in the last session when the Bureau brought in the old questions and then our office looked into all the old questions. So the old local option questions were very specific about different types of retail licenses that you were authorizing. So we found one that was specific to restaurants, hotels, clubs, and part-time golf courses, like just very specific categories were in each question. And so that was pre-1977. And so that led to a situation, this may not be the only problem, but some of the problem was that led to a situation where certain types of entities had been authorized by old local option votes, but maybe not like a non-part-time golf course, or what about a disc golf course? So it wasn't clear exactly which entities were still authorized moving forward. So what occurred in the 129th legislature was this grace period that was discussed, so that even though there are municipalities with certain types of entities that are licensed for on-premises sale, and maybe those weren't really covered by the prior local option questions, that they would have until July 1st, 2022 to make sure they had all the right local option votes collected. But that might have actually required a vote if, for example, you didn't have a disc golf course authorized and you only had part-time golf courses authorized. So I think that the testimony was that actually conducting these votes was made difficult by the pandemic, and maybe the proposal, if you look at the proposed amendment, the proposal before you is to say that if you did have these referendum questions prior to 1977 that were maybe very specific, that those could then be interpreted if they allowed on-premises sales for certain types of entities on, let's say, Monday through Saturday, then you could interpret that yes vote as allowing all types of on-premises sales from Monday through Saturday. If that town also had voted yes for some of those earlier questions for sales on Sunday, then you could interpret that now as a yes for all types of on-premises sales on Sunday moving forward. So just sort of generalizing, and that matches the way the current local option questions are written. The current local option questions talk about on-premises as a whole category, as opposed to hotels in one question, restaurants in another question, golf courses in another question. So that, I think, is the design of the amendment. I had asked the Bureau, I talked to them in between your two meetings today, and I just wanted to clarify, because the language before you, as I read it, it looked like it said that if there had been any on-premises sales permitted either Monday through Saturday or on Sunday, that then all on-premises sales would be permitted moving forward. And I clarified with them that that was not the intent. If a town had made the choice in the past that they were not going to allow sales on Sunday, but they were going to allow them on every other day of the week, then that difference would be kept moving forward. So if the town doesn't want Sunday sales, They're not going to be allowed just because of this amendment before you. That distinction will be retained. That, I think, does mean that you need to slightly change the wording of the amendment, but I'm happy to work on that and then clear it with any of the parties you asked me to clear it with to make sure it really reflects if that's your intent. I will say that I did ask them a different question, and that was because there were so many different local option questions that the voters could have voted on. It could be maybe in some town, they really don't like part-time golf courses. So maybe they approved every other question, but they voted down the part-time golf courses. And so I asked the Bureau what was their interpretation of what would happen in that town moving forward. I'm not saying there is such a town. I'm sure towns love part-time golf courses, but let's just pretend there was. My question to them was, how did they interpret the amendment to affect that town? And they said, the way current law is written, you allow on-premises sales as a category. You don't pick and choose between. And so they would view the approval of some on-premises licensing as the approval of all. And so they would just apply it like current law would apply, which is you can't pick and choose between categories. In my discussion with them, they only could think of one town where that might possibly have an effect, but I think that they're here if you wanted to ask them more questions about that. But I did want you to know that that is an implication of this proposal before you. Whether that's good or bad is not up to me, that's up to you.
Great, thank you, Janet. I think actually what started this whole thing was a golf course, actually. Was the first to find it in the Turner area when we first discovered this.
I forgot that. That was not why I picked that example.
No, I know. It just sparked my memory. So I like the clarifying language that Janet was able to get working with the Bureau. Is there any questions from committee members? I think I do appreciate the work of the Bureau and the affected towns who kind of came up with this and just handed it to us. So Representative Chiazzo.
No questions, Mr. Chair, but I would like to move ought to pass as amended.
Second.
Okay, ought to pass as amended by Representative Chiazzo and seconded by Representative Tuttle. Okay, any further discussion? The amendment is clarifying that stuff with Bablo about bringing those votes forward. I think this will be good for towns so nobody loses their licenses. Okay, any other discussion? All right, seeing none, we'll proceed to a roll call vote if you're ready. Karen, please, and the motions ought to pass as amended.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika. We'll come back to Representative Supika. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop. Representative Dollop, absent. Representative Supika. Representative Supika, absent.
Okay.
9 in favor of the motion, 0 opposed to the motion, and 4 members absent, Mr. Chair.
Great, thank you, Karen. Unanimous of those present. So I think that clears up that part of the morning and or afternoon now. And we'll go to the next list on election related bills. And let's go to LD 930. And thanks to the Bureau and everybody that was helping on the liquor bills.
So LD 930 is an act to revise reporting requirements for Maine Clean Election Act expenditures. It was a concept draft that you had a work session on previously. So I'll take your direction on what to discuss now.
Thank you, Jan. And I don't see Representative Kinney on. I think there was an amendment. Was there an amendment or some other language that came through?
I am not authorized to discuss that.
You are not, right, okay. Okay, I don't see Representative Kinney here either, and I know she had some language. There she is, okay.
Sorry,
I'm trying to do the soft shoe, Representative Kinney, to get you some more time.
Yeah, well, yeah, hold on one second. I'll just hang up on my husband. It's okay. Sorry, I believe, so we're on 9:30?
Yes, 9:30.
Yes,
yeah.
So Representative Poirier had brought in language for Janet. I don't know, I thought I had said, yes, I'm all set with the language, let's bring it forward. But apparently it didn't get shared, so.
I have it, I just couldn't talk about it.
Oh.
So I can share it.
Okay, yeah.
I just need you to say it.
Yeah.
It's a very strange world that works a lot better in person because I can tap you on the shoulder.
Right.
So this is the proposed amendment. It would slightly change the title. So instead of just being an act to revise reporting requirements for Maine Clean Election Act expenditures, it would also say, and to increase campaign finance transparency. And in this section, which is part of the Maine Clean Election Act, and it's the 1125 is the section where all sort of the meat of the act is all of the requirements for qualifying as a candidate or what you have to do after you become a candidate under the act. It would amend the reporting requirements provision to indicate that the reports that you submit to the Ethics Commission have to include an itemized summary of the goods or services purchased with each expenditure that exceeds $1,000. And that's all the summary says too.
All right. Any questions? Representative McCray.
Thank you, Mr. Chair. I've never spent $1,000, so I'm not sure what is current. Do you have that, Janet?
What's the current requirements? Yeah, let me pull up the Clean Election Act. Can you wait one second?
Well, Director Wayne's in the attendees. We can bring him in if that would that help, or do you want to run through that?
Right. Well, right now you'd have to report your expenditures, and he can explain exactly the detail. There are requirements in current law about records you keep. So you have to keep vendor invoices for any expenditure in excess of $50. And the statute says, and the director confirmed at the last work session, that they could then ask to see those records, but you don't have to actually provide the itemized summary automatically in your campaign finance report unless you're then asked to show that record.
Oh, okay, thank you. And I'm getting it now because like for media or literature, I've spent more than $1,000, but that's what you post and you have your records if you are asked to produce them. So I think I answered my own question. So this would just require itemization instead of waiting to see if you're asked to provide the.
I believe so.
Nuts and bolts. Okay, thank you.
Director Wayne, I brought him into the room. If he's available, maybe he could speak to that too, and just to confirm that that's really the only impact we would see here.
Well, this relates to what they actually enter in the Maine Clean Election and in the campaign finance reports. And just as background, all legislative candidates, when they make an expenditure, just like the traditionally financed candidates, they have to sort of state what the purpose of the expenditure is. That's the current requirement. So they do that through entering code from a drop-down list, and then there's a explanation of purpose section where some candidates will say palm cards or mailings, and they, we want to make sure there's some level of detail there, but there's a lot of variety in terms of how much detail they put down in the reports. That's how it's currently done.
Okay.
And so I'm not sure if I answered I hope I answered the question, but I just sort of wanted people to know there already is some reporting of what people are getting when they make a campaign expenditure.
Understood. Representative Keeney.
Thank you, Mr. Chair. I believe that the sponsor of the bill is in the waiting room, and she might be able to explain better the reasoning for the $1,000 with the fact that we have a generic posting, and then the Ethics Commission can ask for more details, but that's not necessarily something that's available to the public right away. And I think that was the reason for putting this bill forward, and she may be able to answer that better.
I have brought in Representative Poirier, so Representative Poirier, if you'd like to elaborate on that, on the intent, that would be great. Oh, and I think she froze, unfortunately.
Mr. Chair, that happens on this committee a lot.
I think it's your magnetic personality, Representative Tuttle.
I would agree.
No, I think Representative Poirier's still having some technical issues there.
Yeah, she started to move, and she's unmuted finally.
It's saying my internet is unstable. I'm in my office at work today, so I apologize about that. I'll try to get it in here before I lose you again. Basically, with the reporting, the reason why I put it in and I put that amount, the amount goes along with other reporting that is in the policies given to candidates. That's why the amount was chosen, because it seems to be a pretty customary amount. But the reason why I put this bill in is because the public doesn't have access to what the expenditures actually are in a lot of instances, especially when it comes to clean election and such. Basically, once an amount is put in, particularly for those large amounts, all they see is where the money's spent, not if it's for, your signs that you're putting on lawns, if it's for your palm cards, things of that nature. So there is interest from the public wanting to know where the public funds are going for those expenditures. So that's what prompted me to put this through.
Okay, thank you, Representative Poirier.
Question.
No, thank you for the clarification. Any questions or discussion from anybody else on the committee? Representative McCray.
Thank you, Mr. Chair. Since this is new, we just got this, correct?
We did.
Can I ask Director Wayne what this might do in terms of the commission? Is this a burden beyond what you already have?
It would not be a huge burden for us. It would be additional information that the candidates would have to be educated on. So we would include it in our guidebook, and it would be something that we would incorporate as part of our compliance reviews. So, I'm just now doing a transaction search on our public access website, just to give you a flavor for printing, for example. Right now, candidates will say there's a description field in the expenditure schedule. So right now, candidates will enter thank you cards, printed letters, printed materials, campaign sign removal, or in the case of mail house, they'll say mailing, mailer, postcard design and mailing, things like that. So this would require them to put an itemization of the number of mailings, for example, or number of postcards, or some sort of quantification of the amount of services. So they would just have to be educated to put that there in the report. And if they didn't put it in the report. We do monitor each and every expenditure made by the Maine Clean Election Act and the traditional finance candidates. So if somebody failed to include the fact that it was 3 mailings, or include the fact that it was 1,000 postcards or 1,000 or 300 signs, if we felt that the itemization was lacking, we'd have to follow up with them, and then the candidate would have to amend the report, which we understand that's necessary, and we will do that. Some candidates are not always responsive to our initial requests. We usually send those by email, and we include a little snippet of what's of the expenditure that's lacking. So it might require a second follow-up, but sometimes we can't get to everything, honestly, because it's not the only thing we do. So thank you.
Representative McCray, follow-up?
Yeah, please, thank you. Director Wayne, how would this compare to traditional funded candidates in terms of record keeping?
Well, I think that probably as of right now, the traditionally financed candidates and the MCA candidates provide a similar level of detail when they're filling out the reports in terms of, printing or mailhouse services. So what this would do is sort of increase the level of detail. Since this would only apply to Maine Clean Election Act candidates, as it's drafted right now, this is part of the Maine Clean Election Act is proposed. It would sort of require more detailed reporting from the Maine Clean Election Act candidates than the traditional finance candidates. So a traditional finance candidate could I don't have a problem, could simply report mailing without any further itemization, whereas a Maine Clean Election Act candidate would need to say 3 mailings or mailings to 1,500 residents or something like that. So that would be more detail.
Thank you. I appreciate it.
Thank you, Representative McCray. Yeah, and I'm wondering too, Director Wayne, if this could create a burden for some of the vendors out there as well. I know, for example, if we use sorry, let me try that again. Sorry, Director Wayne. I'm wondering if this also creates a burden for any of the vendors, because I know, it's certainly when we have a combination of services, we have to have a very detailed invoice and a very detailed receipt. But I don't typically see 1,000 postcards or mailers to 500 people in the district. It's just a mailing, and as long as it's within the reasonable constraints of a cost, it's not necessarily doesn't necessarily trigger any concerns or questions. Would this create any kind of undue burden, do you think, on vendors to have to get even more detailed in an itemized type of invoice that you'd want to see?
I think, I think for some of the vendors that are less formal and, who are just not as thorough in terms of how they fill out an invoice or provide detail to candidates, yes, then the candidates would have to go back to them and say, we need a better itemization because we're a Maine Clean Election Act candidate and this is required of us. So there could be some extra effort involved. I can't really comment on the severity of the burden. I don't really know how widespread that would be, or
sure.
It's just there's additional information that the candidate would need to have on hand, and they would have to get it from the vendor, and then they'd have to put it in our online system. Correct.
Yeah, and my point would be just potentially if a vendor is working with 2 candidates, one's clean election, one's traditional, they'd have to issue in essence they would have to issue potentially 2 separate receipts, one with a lot of detail, one with just a general one, if that was their normal practice, let's say.
That could happen. And I just have to say, some of the vendors I have occasionally, as part of our audit process, do see invoices, and a lot of, some vendors already provide a lot of detail.
Yep.
Some may not. I'm sort of not that qualified in terms of how to answer that. But thank you.
Yep.
Yep.
Understood.
Yep.
Representative Corey.
Thank you. I was just kind of going through my past campaign finance reports just because I was, kind of curious. Like I design for a living, so I always kind of work through myself. But I don't feel like it's ever been that much of a challenge for me to really sort of itemize, each one of these, expenditures as I do them, whether that's, printing services or, web hosting services. I certainly put that in by the month as opposed to, ordering it for the entire campaign season and everything. And I think that what that does is it accumulates sort of a report that is very transparent, not just for the ethics commission, but also for my constituents, or even for the person that's running against me in an election, that they know, what I've done, what I'm, up to and everything. And I think that's a valuable part of providing these types of reports. I don't think that I've ever got as granular, at least from what I'm looking at here, where I said exactly what the number of mailers is. But if I was doing a mailing, it generally was spelled out as this one mailing or another mailing, and it's never like, hey, I spent $6,000 and I did some mailings. It's never been that broad. So I don't think it's that hard to get that granular, in this. I just, I don't know. I think it's transparency, and it's transparency beyond the ethics commission going and asking for something if something seems, a foul to them.
Thank you, Representative Corey. Representative Kinney.
Thank you, Mr. Chair. I guess the concern is, I think where it's coming from is sometimes there are some expenditures, and I did my first ever mailer this last election cycle, and it was somewhere over about $2,200 to $2,500 to do the mailer. But there are some candidates, and this is what brought this forward, that are showing a vendor report where they've spent $5,000. And it's kind of, there's no explanation. You can say mailer, but I mean, I guess there's concern as to just where the mailer is, was this only one mailer? Was this two mailers? Was this an every door mailer? I think that the people are looking, they're just trying to figure out where this is coming from and how much of the money is being spent on their campaign versus pooling it. There's concerns that there's pooling going on, and that's where the transparency needs to come into play for these people that are asked. That's where the question was asked for this, in order to have this bill come forward.
Thank you, Representative Kinney. Representative McCrate.
Thank you, Mr. Chair. I'm concerned about this for two reasons. One is that it's specific to clean elections, which is a program I am very supportive of and think it allows people to run who couldn't perhaps otherwise. And secondly, because I think what we have is fine in terms of people knowing what we're doing. I'm not worried about pooling personally. I don't know where that's coming from, but I think I would like not to see this, so I would make a motion if we're ready for ought not to pass.
Second.
I'm sorry. Is that Representative Tuttle?
I'll defer to, is it Representative Topeka?
Topeka, okay. All right.
I'll third that, Mr. Chair.
Thank you, Representative Tuttle. So I have a motion of ought not to pass by Representative McCrate, seconded by Representative Topeka. Representative Corey.
Thank you, Mr. Chair. So I don't personally have a concern about pooling. I've heard, people make that sort of statement out there. My personal concern is sort of economy of scale, that, having, been in the design and printing business, I know that if I'm working with, dozens of candidates, there's a certain economy of scale and, repeating work, making it so that all the designs are, kind of the same. It saves a lot of time. It brings down the costs. Also, that can happen in printing as well. What we can do is we can put, something on a press, send it to a particular, printing company, they can do a gang run on the press, instead of, printing off, 4 sets of plates for 20 people, they might be printing off, 8 sets of plates, 4 sets a piece for 20 people, being 80 sets of plates, and they could get down to 8 plates, which significantly cuts down, on price and everything else. So, even within the Maine Clean Election Act, we have that, people need to be buying things at what the market price is. Well, when you gang run, when use economy of scale and design and marketing and everything else, you're no longer, buying things at, what the market price is. So, for me, I'm going to have to, oppose this motion, because this is really all about transparency to me. And if the public doesn't know specifically what we're spending our money on, then what are we doing? We're using public funds to run our campaigns, and this is somebody that's run clean 4 of my past elections. 2, thankfully, I got to return a bundle of cash back to the Maine Clean Election Systems, but I have no personal problem with transparency in the way I conduct my business as a candidate. Thank you.
Representative Kinney.
Thank you, Mr. Chair. Yeah, I oppose the pending motion, and actually what I will amend further, and I'd be more than happy to have this apply to all candidates, not just clean election candidates, with my amendment.
Okay, well, there's a motion on the floor not to pass from Representative McCrate. You were suggesting to make a second amendment on top of the amendment?
No, I'm just letting people know ahead of time what my minority report would, or possibly my majority report could end up being, and where the concern was around this being just for clean elections. I'm fine with it being for all candidates. And so if people wanted to take that into consideration when casting their vote, they would have that opportunity.
Okay. Representative Corey.
Thank you, Mr. Chair. I'd just like to thank Representative Kinney for, expanding this to all candidates. I think, like I said, that level of, trust, by the public is so crucial, as we move into this next election season. So thank you, Representative Kinney.
All right, well, now we have a senator present, so we could commence to a vote. Any other questions, concerns, comments?
I think Senator Farron is looking for where that senator actually is.
Well, unfortunately, his title says that it's him. So, motion on the floor is ought not to pass. And if the committee is ready, Karen, if you could call the roll, please.
Senator Lucchini. We can come back to Senator Lucchini. Senator Hickman. Senator Hickman, absent. Senator Farron.
Nay.
Senator Farron, nay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Nay.
Representative Kinney, nay. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
No.
Representative Corey, no. Representative Dollop. Representative Dollop, absent. Senator Lucchini. Senator Lucchini, absent. Seven in favor of the motion, 3 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So the motion ought not to pass prevails. The 3 absentees will have until noon tomorrow to register their vote.
Can I clarify all the minority reports?
Yep. Yeah, I almost did it. Representative Kinney, I think you almost laid the groundwork for that already, but please go ahead.
Yeah, so it's basically the amendment that was presented with, but it applies to all candidates, not just going election candidates.
Yep. Traditional, yep.
Thank you, Representative Kinney. Representative Tuttle.
Mr. Chairman, I have to pick up my grandson at school, so I'll be gone for about a half an hour, but knowing the way Fridays have gone, I'm sure that we will still be here. Yeah.
Well, I'm sorry that you just jinxed us, but we'll do our best.
All right, we can just make it real quick. Let's go right through all of them.
All right, so that concludes the work session on LD 930. I guess we could move into LD 981, Janet, when you're ready.
So 981 is an act to strengthen the integrity of the Maine Clean Election Act by limiting the amount of money paid to political operatives. You've already had a work session on this as well. I can go through all of the changes that the bill makes, but I'll look to your direction.
I'm okay just moving to committee discussion unless people have questions or want to hear anything new. Anything from the committee? Questions, comments? Anybody willing to make a motion? Representative Wood.
I'd make a motion ought not to pass. I feel strongly that each candidate's campaign is different and individual, and the purpose of the program is to give the candidate a lump of money for them to see fit for however they think is best for their campaign. So I don't think we should be getting into the detail of what's okay and what's not okay. So I move ought not to pass.
Okay, motion of ought not to pass by Representative Wood. Is there a second?
I'll second.
Seconded by Chairman Lucchini. Discussion, debate? Representative Corey.
Thank you, Mr. Chair. I think that it's another transparency issue for me. You know, when I kind of found out that, you know, a campaign could, you know, go and, you know, pay a, you know, consultant $2,500 for I don't know how many hours work or whatever, you know, I don't know what sort of the value, you know, of that is without some kind of a detailed expenditure. I certainly don't believe, you know, campaigns are a jobs program. So I'm gonna be opposing this motion. Thank you.
Thank you, Representative Corey. Chairman Lucchini.
Thank you, Mr. Chair. I think I'm not exactly sure how frequently this happens, but my bigger, I think, concern is what we've seen in the governor's races, to be honest, in paying individuals. I really haven't heard that this is a big issue, and I don't really know the exact cause for why we're putting this in, but I think when it comes to big spent money, it's the governor's race where I've had some concerns.
Okay, thank you, Senator Lucchini. Any other question or comment from the committee? 2, 3, 4, 5, 6, 7. Okay, so we now have 7. We can move to vote. Karen, if you could call the roll when you are ready, please. The motion on the floor is ought not to pass.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. I can come back to Senator Farren. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Nay.
Representative Kinney, nay. Representative Harrington.
Nay.
Representative Harrington, nay. Representative Corey.
No.
Representative Corey, no. Representative Dolph. Representative Dolph, absent. Senator Farren.
No.
Senator Farren, no. Is there anyone else I was coming back to? 1, 2, 3, 4, 5, 6. 6 in favor of the motion, 4 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So the motion ought not to pass prevails. The 3 absentees will have until tomorrow at noon to cast their votes. And Senator Lucchini is back, so but he's on the phone. So I will not.
Can you take it for just a second?
I got it. I got it. I'm sorry. Yes, Janet. Thank you again. The minority report, please.
So on this one, ought to pass as amended, and it would be to remove the hourly log requirement, just limiting the amount of money paying to an individual. So would basically, it looks like it would eliminate section 3, possibly section 4, just or it might just be the part about the log requirement. We want to get rid of that, the hourly log. Is that enough for you, Janet?
Yep.
Great, thank you.
All right. Thank you, Jen. I'm sorry. I always forget about the minority report. I don't know why.
I won't let you forget, because unfortunately, that's always where I am.
Not always. Not always. Representative McCray.
Thank you, Mr. Chair. At the risk of just being annoying, the vote would be till Monday as opposed to tomorrow.
Yes, thank you. Thank you. No, you're correct.
The public needs to know that we have weekends. Sort of.
The chair is in error. I'm going to use to practicing that a lot. So yes, until Monday at noon. Thank you. Thank you. Thank you. Okay. If there's nothing left that I've forgotten, then I think we're ready to move on to LD 1284 when you are ready, Janet.
LD 1284 is an act to amend the Maine Clean Election Act and related laws. It makes many changes to the Maine Clean Election Act, which I'm happy to summarize for you, but you did already have a work session on April 14th, so I'll take your direction.
Maybe you could go through just a quick summary, just super quick to refresh us a little bit. I know we're getting a little long in the day and we've had a lot of stuff in front of us.
Sure. So it changes the title of the act to the Maine Publicly Financed Election Act. It changes the amount of general fund revenue transferred annually from $3 million to $2 million. It eliminates the ability of gubernatorial candidates to receive funding under the act. It restricts seed money contributions to not just registered voters, but registered voters in the electoral division for the office the candidate's seeking. It eliminates the ability of Clean Election Act candidates to obtain supplemental fund distributions. It changes the amount of distributions to the amounts that were in effect in 2014 prior to the 2015 Citizens Initiative. It clarifies that when the Ethics Commission adjusts the distribution amounts every 2 years, that it has the authority to reduce the amounts. Those adjustments are based on the Consumer Price Index. It doesn't change any of that, just it clarifies that you can reduce it as well. It also has a couple of changes outside of the Clean Election Act. So it repeals the requirements for disclosure of the top 3 funders when an entity finances a communication with an independent expenditure. And it also clarifies that individuals who make independent expenditures don't have to file reports with the Ethics Commission. It's only non-individuals who make independent expenditures. I think that's what it does.
All right. Thank you, Janet, for the recap. Much appreciated. Discussion from the committee or a motion? Don't everybody jump at once. It's gonna be a long day.
Motion ought not to pass.
All right. Motion ought not to pass by Representative Supika. Is there a second?
Second.
Seconded by Representative McCray. Discussion? All right, before we go to a vote, I need a senator, so let me see if I can scrounge one up very quickly.
It was magic.
There he is. Look at that. I didn't even get to finish typing. Chairman Lucchini.
Apologies, sorry. Keep the phone ringing off the hook. And this is on LD 1284, is that right?
Yes. Motion on the floor is ought not to pass on 1284.
Great, and I think just from my perspective, I think we dealt with a lot of these through different bills that we've already voted, the items within this. So I think it's actually kind of repetitive to some of the other ones, although this does go a lot further on certain areas, but I think we did vote for some of these other issues.
All right. Thank you, Chairman Lucchini. And if we are ready, before his phone rings again, can you call the roll, Karen?
Senator Lucchini.
Sorry, and can you remind me of the motion?
Motion is, oh, sorry, go ahead, Karen, sorry.
Ought not to pass.
Thank you, sorry about that, yes.
No worries. Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. I can come back to Senator Farren. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop. Representative Dollop, absent. Senator Farren.
Yes.
Senator Farren, yes.
We're alternating who bounces in and out.
10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So motion ought not to pass prevails by unanimous of those present. The 3 absents will have until noon on Monday, according to Representative McCray, to vote. All right, so that just leaves on our list LD 1442. Janet, I think we've already had one review on this, but I think is there a new amendment on this as well that you can share?
Sorry, I was muted. I don't think we've had a work session on this.
Oh, we haven't. Okay, my apologies then. There's been a lot of Gronkowski bills this time around, so we're ready for the analysis if you're ready.
I'm not suggesting you have to listen to it, but I just wanted you to know.
No, we're happy to listen to it, of course.
You could be tired of me, and I wouldn't blame you.
Not
Neither
at
would my
all.
teenage daughters. They might agree.
Never.
They're delightful daughters, but they do get tired of me. So LD 1442 is an act regarding publicly financed legislative candidates and competitive primaries. Under current law, as you all know, legislative candidates certified under the Maine Clean Election Act receive a single distribution of revenue during a primary election and a single distribution if they're involved in an uncontested general election. If they're part of a contested general election, however, they can choose to collect additional qualifying contributions to receive up to 8 supplemental distributions of fund revenue. And if I wasn't clear, I'm just talking about legislative candidates. I don't know if I skipped over that word. So this bill would amend these provisions of the Clean Election Act to authorize a legislative candidate under the act who faces a contested primary election the option to choose to collect additional qualifying contributions and thereby qualify for up to 4 supplemental distributions of fund revenue. If the candidate later faces a contested general election, however, the total supplemental distributions the candidate may receive for that general election would be decreased by the number of supplemental distributions the candidate opted to receive for the primary. That means that a single clean election certified legislative candidate may not receive more than 8 supplemental distributions total for the primary and the general election. So as you look, because you cannot have a bill analysis without a table, under current law for primary elections, whether they're uncontested or contested, whether you're a Senate or a House candidate, you just get 1 distribution amount. And the bill changes that. For Senate candidates, they can qualify for up to 4 supplemental payments of $4,285, and they'd have to collect 30 qualifying contributions for those. And that would then mean that during the general election, if they're also in a contested election, that they would reduce the number of supplemental distributions they're authorized for. I would note that this amount, $4,285, is less than the supplemental distribution amount under current law for the general election, and so are the number of qualifying contributions. So it's less qualifying contributions for each batch, and then a less supplemental distribution payment. And the House candidates, it's a similar change, just with different dollar amounts because it's a House race in a smaller district. I would point out also that in this table, I included the statutory amounts. So this is what the statute would say for all of these amounts. Those amounts are subject to biennial adjustment by the Ethics Commission, and that was something that was raised in the public hearing. So I'll talk about that in a second. So in the sponsor proposed an amendment during the hearing, and that amendment would correct mathematical errors regarding the number of additional qualifying contributions that candidates must collect. If you look at the bill as it's currently drafted, it looks like you can get 8 supplemental distributions or 8 batches worth of additional qualifying contributions. That's an error. It should be 4. So it's just changing those numbers to reflect what the bill intends. It also would clarify that a legislative or gubernatorial candidate who collects those additional qualifying contributions before a primary election can choose to use those contributions either for that primary or for the general election, that they'd have that choice, that just because of the point in time and when they collected the contributions doesn't dictate what they're used for. As far as the statutory distribution amounts, as you know, they're biannually adjusted based on, in part, on the Consumer Price Index. The Ethics Commission compared a table that lists both the statutory distribution amounts and the adjusted amounts for the 2022 election. So they've already made those amounts for the next election. The sponsor expressed some concern that by including some but not all of the statutory amounts in the text of the bill, it wouldn't be clear whether the legislature intends to reset those distributions at that amount and then keep all other distribution amounts that don't appear in the bill at the higher adjusted level for the 2022 election. So she was just concerned about the ambiguity of which numbers you adjust upward from for the 2022 election. So she proposed amending the bill. Although she didn't put it in her amendment, she proposed you might consider further amending the bill to replace all of the 2015 statutory distribution amounts with the new adjusted amounts so that it's clear, and you reset the clock so that every amount for the 2022 election will be set forth in statute, and then all of them can be adjusted moving forward together. So this is the table that the Ethics Commission prepared. The middle column are the statutory amounts. The right column are the amounts that they've made as adjustments for the 2022 election. And then these yellow highlighted amounts, those are the proposed supplemental distributions for the primary elections for House and Senate candidates if they're in a contested election. And the Ethics Commission took the amounts that the sponsor had in the bill and adjusted them upward by the same percentage amount that all of the other amounts have been adjusted upward over time. And so it came up with these particular amounts of money. Some communications from the sponsor that went out to the whole committee. When she looked at these tables of numbers, she would say, if you do accept her amendment, put all of these numbers in the statute directly, and then change this 1169 to 1175, and change this 4683 to 4675. That's how she would propose we deal with that particular issue. There was another issue that was raised about the timing of the primary supplemental distributions, because commission staff would be required to review all of the additional qualifying contributions submitted by the legislative candidates for the contested primary elections during April to May of the election year. At that same time, the staff are already busy reviewing all of the legislative candidates' requests for certification, which are due on April 20th. And after the public hearing, the executive director of the Ethics Commission provided additional input via email. And I put it in a box because this is not my language. I just cut and paste from the email here. And he explained that during those last 2 weeks of April and then during early May, they're very busy. If the bill was enacted, it would be hard to estimate exactly how many candidates would take advantage of the supplemental payment provisions, but it could require the staff to review several hundred additional qualifying contributions during the April to May period. They're very happy to cooperate with the legislature, and if that's what you want to do, they're happy to go forward, but they would propose that maybe there should be some unallocated language that would require the Ethics Commission to invite comment from the public, the parties, caucuses, and anyone else that you all think is appropriate to develop some written procedures for prioritizing requests for certification and supplemental payments so that they know which tasks to address first or second. In an email from the sponsor that I think she sent out today, I know she definitely told me I could talk about it. She proposed, instead of adding this provision that the Ethics Commission suggested, to have some kind of public comment on prioritizing, to perhaps use a date of May 6th for when the primary supplemental distributions, when those distributions would go out, and perhaps that might give the Ethics Commission more time. But I can't really explain the calculation of that date. She put it in her email, but I'm not the best person to explain that and how it would impact the Ethics Commission, but that was her additional proposal.
Thank you, Janet. Any questions or comments from the committee? Chairman Lucchini.
Thank you, Mr. Chair. I guess I understand the intention of the sponsor. However, I think the net effect of this is that it will make the program more expensive because more people will spend more in the primary. And just given the budget situation that we find ourselves in and that we're curtailing everything, I can't support adding money to making campaigns more expensive at this time. So I'll be voting against the bill.
Okay, was that a motion, Senator Lucchini? No, okay. Representative Kinney.
How's this? I make a motion not to pass.
There, okay, that is a motion.
I'll second.
I'm not used to making motions.
So motion ought not to pass by Representative Kinney, seconded by Senator Farren. Discussion debate. Senator Farren, did you have anything you wanted to add, or? No, okay, sorry. Any discussion or debate from the committee? Representative Corey.
Thank you, Mr. Chair. Yeah, I think this is an interesting one because I almost feel like it's putting more money in politics, and I think the intent of the program is to help get money out of politics. I think that also, what was interesting is, we talked about sort of the idea of like having, open primaries, earlier. this session. And the idea here is that you're going to have people spending a ton of money in closed party primaries as opposed to in the general election. So I don't even think this is very fair to independent candidates, because if you were to have an independent or an unenrolled candidate in there, the person that's running in one of these primaries where they're spending a lot of money, will actually, have a good, leg up or a jump on doing, a lot of, self-branding and name recognition and everything else. So I think in fairness, this probably isn't the best idea. And hey, if you need more money to run, in a primary because you're traditional and probably likely, you might actually win, that general, because you really see those competitive primaries in places where there's, kind of no general generally. You can always, run traditionally if you're a good candidate. Anyway, good enough. Thank you.
Thank you, Representative Corey. Any other discussion from the committee? All right, seeing none, the motion on the floor is ought not to pass. Karen, let me see, wait, 1, 2, 3, 4, 5, 6. Yep, we're good. When you're ready, please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. The motion ought not to pass prevails by unanimous vote of those present. The 3 absentees will have until noon on Monday to register their votes. I think that's it for us for work sessions. Janet, do you have anything else on our list that we need to address?
I just wanted to say Happy Mother's Day to any mothers.
Very nice. Very nice. Representative Riley.
I was just seeing with Karen if I had missed a vote earlier when I was gone.
Uh, 1643, the liquor errors bill.
Okay.
Let me see if there's another one. I think that's it. Like that. That is all you've missed. Did you want to vote on it?
Sure.
Vote was a carryover vote.
Sounds good.
All right, duly noted. You voted to carry over LD 1643. Yes. Thank you.
You good, Representative Riley? Okay. Representative Kinney.
Thank you. Did I miss something? Did we do 1518 today, or did we change the schedule and drop that one from the work session? Or did I just miss both?
It was postponed.
Thank you. That's all I wanted to know.
Any other questions, concerns, comments, consternations, complications? Senator Farren almost took the bait on that one. Representative McCray.
Just happy Mother's Day back to Janet. Thank you.
Very nice. Very nice. He's looking for the button. I know he is.
No, that is a great, exactly. Happy Mother's Day to all the wonderful mothers out there. That is exactly right. One of us males should have thought about that, but Senator McCray, thanks for bringing that up. That's absolutely.
I appreciate the reminder as well, so thank you.
There's time to recoup.
Yeah, there's always time to recoup. I never get it right. We never have enough time to do it right, but I always have enough time to do it again. All right. On that note, thanks. Sorry, Chairman Lucchini.
That's fine. I was just going to say we have to meet. It looks like Monday, Tuesday, Wednesday next week. So we do have a Tuesday to pick up some new bills we've got, and potentially Friday. And I guess just a reminder, the POs just sent the letter about changing the time of voting and reminding people to vote on jackets when they come by emails. And they have, technically we have to ask for permission to meet beyond today, which is ridiculous really that we have to do that given that everything is slower on digital. So we had to put in a request, and it's absurd, but if there's anything weird about us getting rejected, we'll let you all know. But I think they should be flexible in the time. What's that?
It was approved.
Oh, it was approved? Good. I would assume that it would be.
We
it'll be a
picked
flexible schedule from here on out. Sorry.
Yeah. We also picked up the day we were going to be in session on the 13th. So I'm not sure if we'll use that or not, but we'll let everybody know where we're at.
Yeah, and we lose a committee day now because they rescheduled us on Wednesday the 19th. So we're just going to have to be really flexible from here on out.
Okay, if there's nothing else, I'll contribute my obligatory Happy Mother's Day to my mom. And then we will, if not, we will adjourn. Enjoy the weekend, everybody. And we will see you all Monday morning.